he'd start yelling at him.
And he knows because he's been yelled at, right?
Well, no, he shows up on calls and yells at people. Well, sir, anything good?
Not much. and they wanted to come back again. So again, thank you for being here this morning. You've been summoned as a prospective juror in a criminal case entitled State of Ohio versus Matthew K. Broadwater. Mr. Broadwater is the defendant in this case, meaning he is charged with committing a criminal offense. Mr. Broadwater is charged with committing 3 separate offenses. Specifically, the indictment alleges in count 1 that on or about the 16th day of September 2022 in the city of Eastlake, Lake County, Ohio, Matthew Broadwater did knowingly convey or attempt to convey onto the grounds of a detention facility or of an institution, office building, or other space that is under the control of the Department of Mental Health and Addiction Services, the Department of Developmental Disabilities, the Department of Youth Services, or the Department of Rehabilitation and Correction, a drug of abuse. Count 2 states that on or about September 16 of 2022, in Eastlake in Lake County, state of Ohio, Matthew K. Broadwater did knowingly obtain, possess, or use a fentanyl-related compound or a mixture, preparation, or substance containing a fentanyl-related compound. Count 3 alleges that on or about the 17th day of December 2022 in the city of Eastlake, Lake County, Ohio, Matthew K. Broadwater, knowing he was under detention other than supervised release detention or being reckless in that regard, did purposely break or attempt to break the detention or purposely failed to return to detention, either following temporary leave granted for a specific purpose or a limited period, or at the time required when serving a sentence in intermittent confinement. At the time of the commission of this offense, Matthew K. Broadwater was under detention for possession of a fentanyl-related compound, a felony of the 5th degree, and or illegal conveyance of drugs of abuse onto the grounds of a specified governmental facility, a felony of the 3rd degree. The indictment, which sets forth the charges that I have read to you, is not evidence. It is used to inform Mr. Broadwater that he has been charged with these offenses. The fact that it was filed may not be considered for any other purpose. Mr. Broadwater has pled not guilty to the charges. The plea of not guilty is a denial of the charges in the indictment and puts in issue all the essential elements of each offense. The state of Ohio and Mr. Broadwater are entitled to jurors who approach this case with open minds until such time as a verdict is reached. It would be unfair and improper for you to decide this case based only on part of the evidence or without hearing the court's instructions or the arguments of law, or the arguments of counsel, rather. Do not jump to conclusions on the basis of the first or even the last argument or the first or last evidence that is presented to you. In addition, jurors must be free as humanly possible from bias, prejudice, or sympathy, and not influenced by preconceived ideas either as to the facts or to the law. You will receive the facts from the witness stand. Instructions as to the law will be given to you by the court, and it is your sworn duty to accept and apply the instructions that are given to you. I want to begin by explaining the procedure by which 13 of you will be selected to serve as jurors in this case. As I said, each of you are undoubtedly qualified to be jurors in this case. However, there could be something that could disqualify you in this particular case under the particular or specific facts and issues present in this case. So we're going to go through a process whereby I ask you questions and counsel for each side ask you questions. This part of the trial is called voir dire. It's an attempt to learn a little bit about you and your background to make sure that we have a fair and impartial jury in this case. These questions are not designed to pry into your personal affairs, but to discover if you have any knowledge of this case or any preconceived opinion that you cannot set aside, or if you have had some experience in your personal or family life that might cause you to favor either party in this case. These questions are necessary to assure that we have a fair jury in this case. I will ask you questions first as a group. If you have a response, raise your hand and I'll call on you. Every time an individual speaks, the juror number must be identified either by whoever is asking the question or the juror who's answering the question. We do this so that the record is clear as to who is talking. After I've asked my questions, the attorneys for each side will be asking you questions as well. And again, they're not intended to be offensive or to pry in any way, but to assure that we have a fair jury in this case. Now, I'm sure you would understand that a person who has personal knowledge of the facts of this case, or who has already made up his or her mind about how this case should come out, would not be able to serve as a fair juror. That person would be excused for what is called good cause. After we are done with the questioning, myself and the two attorneys, then I'll meet with counsel out of your presence, at which time 13 individuals will be identified as trial jurors in this case. One of the 13 will be an alternate. That person will not be identified until just before deliberations begin. Now, the most important thing that I need to stress to you is the importance of being honest in answering these questions. We need you to be open and honest. If when you're being asked a question, if you don't want to talk about it in front of the whole panel, let me know that, and we'll talk privately with everybody else out of the room. Now, seated directly in front of me, I'm pointing to Taylor Linden and Kara Salim. They are the assistant prosecutors in this case. Would you introduce yourselves, please?
Good morning, ladies and gentlemen. I'm Taylor Linden from the Office of Charles E. Colson. I'm here with Cara Salem and Officer Cole Eden from the Eastlake Police Department.
Thank you. And seated at the other table are attorneys John Fatica and Nicole Novotny.
Good morning, ladies and gentlemen. My name is John Fatica. My co-counsel is Nicole Novotny. Our client is Matthew Broadwater.
Thank you. You've met Bob Gonzalez. He's our bailiff. It's his responsibility to keep you together and to keep you moving and to not let anybody speak with you throughout the course of the trial. Kathy Miller is our court reporter. She's responsible for taking down and recording everything that's said in the courtroom. Now, as I said, you're going to be called upon to answer questions, and when I do call upon you, as I said, the juror number needs to be identified. When you're answering questions, it's pretty common that people will either nod their head or give a response that's kind of like uh-huh or that's not going to work, especially the nonverbal responses. So she needs to take down whatever's being said, so inevitably you're going to hear me remind you that you have to verbalize your answers. Now, those who participate in a trial must do so according to established rules. This applies to the witnesses, the judge, the jurors, and the lawyers. The lawyers present the evidence through the questioning of witnesses, which must be done according to the rules. The judge enforces the rules and determines what evidence may be admitted. At times during the trial, a lawyer may make an objection to a question asked by another lawyer or to an answer by a witness. This simply means that the lawyer is requesting that I make a decision on a particular rule of law. Do not draw any conclusion from the objections or from my ruling on those objections. These only relate to legal questions that I must determine and should not influence your thinking. As jurors, you will be the sole judges of the facts, the credibility or believability of the witnesses, and the weight to be given to the evidence. Later, the court will furnish the law, which you will apply to the facts that you find. It is your sworn duty to accept the law as it is given to you by the court. Once the jury is selected, the procedure for the trial is as follows. First, the state will outline in an opening statement what they expect their evidence will show. The defense may then, but need not, make an opening statement. These opening statements are not evidence. They are a preview of the claims of each party designed to help you follow the evidence as it is presented to you. Then the state offers evidence to support its claim. The defendant may then present evidence but is not required to do so. If the defense does offer evidence, then the state may offer rebuttal evidence. The trial concludes with the instructions of law and the arguments of counsel. You would then deliberate on your verdict. A criminal case begins with the filing of an indictment. The indictment informs the defendant he has been charged with an offense. The fact that it was filed may not be considered for any other purpose. The plea of not guilty is a denial of the charge and puts in issue all the essential elements of each count. The defendant is presumed innocent until his guilt is established beyond a reasonable doubt. The burden of proof is on the state of Ohio to prove the facts necessary for its case beyond a reasonable doubt. The defendant must be acquitted unless the state produces evidence which convinces you beyond a reasonable doubt of every essential element of the offenses charged in the indictment. Reasonable doubt is present when, after you have carefully considered and compared all the evidence, you cannot say you are firmly convinced of the charge. Reasonable doubt is doubt based on reason and common sense. Reasonable doubt is not mere possible doubt because everything relating to human affairs or depending on moral certainty is open to some possible or imaginary doubt. Proof beyond a reasonable doubt is proof of such character that an ordinary person would be willing to rely and act upon it in the most important of his or her own affairs. Evidence is all the testimony received from the witnesses, the exhibits admitted during the trial, facts agreed to by counsel, and any facts which the court requires you to accept as true. Evidence may be direct or circumstantial or both. Direct evidence is the testimony given by a witness who has seen or heard the facts to which he or she testifies. It includes exhibits admitted into evidence during the trial. Circumstantial evidence is the proof of facts or circumstances by direct evidence from which you may reasonably infer other related or connected facts which naturally and logically follow according to the common experience of mankind. Direct evidence and circumstantial evidence are of equal weight. The evidence does not include the indictment or the opening statements or closing arguments of counsel. The opening statements and closing arguments of counsel are designed to assist you. They are not evidence. You are the sole judges of the facts, the credibility of the witnesses, and the weight of the evidence. To weigh the evidence, you must consider the credibility of the witnesses. You may apply the tests of truthfulness which you apply in your daily lives. These tests may include, but are not limited to, the appearance of each witness upon the stand, the reasonableness of the testimony, the opportunity to see, hear, and know the things concerning which they testified, the accuracy of memory, frankness or lack of it, interest and bias, if any, together with all the facts and circumstances surrounding that testimony. Applying these tests, you may assign to the testimony of each witness such weight as you deem proper. You are not required to believe the testimony of any witness simply because they are under oath. You may believe or disbelieve all or any part of the testimony of any witness. It is your province to determine what testimony is worthy of belief and what testimony is not worthy of belief. The testimony of a defendant is to be weighed by the same rules that apply to other witnesses if the defendant takes a stand and testifies. The defendant has the Fifth Amendment right to not testify in this trial. If the defendant chooses not to testify, you shall not consider that decision for any purpose. You should not decide any issue of fact merely on the basis of the number of witnesses who testify on each side of an issue. Rather, the final test in judging evidence would be the force and weight of the evidence regardless of the number of witnesses on each side of an issue. The testimony of one witness believed by you is sufficient to prove any fact. The court instructs you not to converse with the attorneys, parties, or witnesses during the trial. Likewise, the participants in the trial must not converse with you, and in fact, they are ordered not to talk to you until this case is concluded. If anyone should attempt to discuss a case with you, report that incident to me or to the bailiff immediately. Do not investigate or attempt to obtain additional information about this case outside the courtroom. It is improper for any of you to attempt to do so. You are instructed not to read, view, or listen to any report in any media on the subject of this trial. Do not permit anyone to read or comment upon them to you or in your presence. Such reports may be incomplete and inaccurate. You may only consider and decide this case upon the evidence presented to you at the trial. If you acquire any information from an outside source, you must repeat it or report it. If you realize during the course of the trial you have personal knowledge of the facts of this case, inform the bailiff as soon as possible. Now, as I said at the beginning, I'm going to ask you some questions first as a group. If you are going to respond to that question, please raise your hand and we'll identify you only by juror number. The first question is, does anybody know any of the four attorneys seated here today? Does anybody know Officer Eden or Mr. Broadwater? Juror number 22, who do you know? And how do you know Officer Broadwater? I'm sorry, you said Mr. Broadwater or Officer Eden? Mr. Broadwater? How do you know Mr. Broadwater?
My ex-husband has a child with a sister.
All right. And when is the last time you saw Mr. Broadwater?
I personally have never seen him. I just know of.
Okay. Does the fact that you know of him by the relationship you indicated, would that impact you if you were seated as a juror in this case? All right. Would you be able to be fair to Mr. Broadwater and to the state of Ohio if you are selected as a juror? Would that present you any problems whatsoever? Okay. Anybody else know Mr. Broadwater or Officer Eden? All right. Anybody know me? Juror number 19, how do you know me?
Interviewed you once in my previous job as a reporter at the News Herald.
Okay. How did I do on that interview? You're nodding your head. That doesn't work.
I was weighing that answer, Judge.
Okay. Well, you got to give me one. I'm not going to let you off the hook. What did you say? Did you say okay? How did you think you did in the interview?
Pardon?
How do you think you did in the interview?
I believe I fared reasonably well, but not as well as you as the other interviewees.
Okay. All right. Good enough. Good enough. Anybody else? Juror number 9. Go ahead.
For my job, I work for an insurance company, auto insurance, so I've had a few mediations and cases in front of you. Hasn't been for prior to COVID though.
Okay. Would the fact that you've had some dealings with me on civil cases, would that impact you in any way? Would you be able to be fair to both sides? And 19, same question that I asked, I forgot to ask you this, but would the fact that we've had some contact in the past through your profession, would that impact you in any way if you're seated as a juror?
No.
Okay. Anybody else? Juror number 1, go ahead.
A few years back, I was pursuing a paralegal degree at Lakeland, and I did an internship at the public defender's office. And I did spend some time observing your court.
Okay. What kind did you observe hearings?
Hearings, yeah, and there was at least once where I was with the lawyers in your chambers
Okay.
listening to people discuss the case.
Okay. How long ago was that? Well, the last time do you think that was?
That was probably 2016.
Okay. If you are selected to serve in this case, would that experience impact you one way or another so that you couldn't be fair and impartial?
No, it would not.
All right, you'll be fair to the state and the defendant?
Yes.
Okay. Anybody else? Your number, please?
30.
Okay, go ahead.
I know Taylor Linden from my employment with Lake County Job and Family Services.
Okay. And when's the last time you had contact with Ms. Linden? And was that through a proceeding maybe in juvenile court?
Probably.
All right. If you are selected to serve in this case, would that influence you to one degree or another, to one side or another? No? Okay. Would you be able to be fair to both sides in this case?
Yes.
Okay. Anybody else? All right. Do any of the potential jurors know each other? All right. Juror number 5, which other juror number do you know?
I don't know her number.
Who was it? Who's
34.
34?
34.
All right. How do you know 34?
She's a neighbor, friend of my wife's. They go on walks with the dogs.
You don't go?
No, I work, so they
Okay.
go on walks.
Okay. Where does she live in relation to you? Same street?
We live on Huntoon, they live on Williams, Huntoon and Williams intersect, so
Okay.
it's very close.
All right. If you're seated as a juror and 34 is seated as a juror, and you guys sat here and listened and came to opposite conclusions as to what the facts were, would that impact your relationship with 34?
No.
Your wife and her could still go on walks with the dogs without a problem from you? Okay. All right, 34, same question. If you're both seated together and you guys come to opposite conclusions, would that cause you difficulty the next time you saw him? Okay. All right, anybody else? Number 2, who do you know?
I know juror number 3.
And how do you know 3?
I was a client of his. He was an optometrist since retired.
You know what, I knew that too, because my wife used to go to him. Actually, she wants you to unretire so she can go back to you. But I don't think you're going to do that. All right, now, if you're seated with 3 on the jury, would that cause you any difficulty at all?
No.
When's the last time you went to see juror number 3?
21.
Okay. All right. Any problems with you, juror number 3, and sitting with 2?
No.
Okay. All right. Anybody else? Your number, please.
27.
27. Who do you know?
One of my veterinarians, I don't know his name.
What number?
Number 5.
Okay. All right. And when's the last time you saw juror number 5?
Last week.
All right. And was it a good experience?
Oh, yes.
Okay. All right. Do you regularly go to juror number 5?
No.
Okay. All right. If you're seated and 5 is seated, and you know the question coming, if you guys had a different view on the evidence, would that cause you any difficulty sitting with juror number 5? All right. All right. Any issues with you, number 5, with 27? Okay. All right. I think I saw some other hands. Number 8, who do you know?
I think I know jury number 3. After jury number 2 mentioned he's an optometrist. I did go 2 years ago.
Okay. Any difficulty sitting if you're selected with juror number 3?
No.
All right. And number 14, who did you know?
I know number 24.
Okay. How do you know 14, or 24 rather?
I went to school with him. I haven't seen him since probably 7, but I know of him.
Okay. Any difficulty if the 2 of you were seated together? You're not going to have whole arguments about school?
No, sir.
Okay, okay. 24, any issues with you sitting with 14?
No.
Okay. All right, anybody else? Okay. And the reason I ask those questions is because you're going to get in the 13 or the 12 of you who excluding the alternate will be in there talking about the case and sometimes maybe mildly arguing about the case. And if you think that you would automatically side with that person because you know them, that could be a problem, okay? If you know them and you don't like them and you decided against them just for the sake of deciding against them, that would be a problem too. So is there anybody in that group that I talked to that would not be able to maintain their own position if they believed that that was correct, even if somebody was arguing to the contrary that you knew? All right. And by the same token, would you be able, is there anybody who would not at least listen and consider to the arguments of the others? Okay, so I assume that silence indicates you're all going to do your job, proper deliberation, state your case, and listen to what others believe is the case. Okay? All right. All right. From the charges that I read to you, is anybody familiar with this case? All right, has anybody served on a juror before, and by that I mean actually deliberated or served and listened to a trial, whether you deliberated or not? Okay, let's start with number 1. When did you serve? How long ago?
The last one was probably
And where was that?
It was, here, it was in Judge Lucci's court.
Okay. Was it a civil case or a criminal case? All right. Did you deliberate on a verdict in that case?
No, I ended up being an alternate.
Okay.
And I also had another jury duty about 20 years ago in federal court downtown.
Okay. Did you deliberate on that verdict?
Yes, that was
Okay.
a criminal case.
Did the federal case take a lot longer than the case you had here? 8 weeks. Those feds like to drag everything out. So, all right, anything about those two experiences that would cause you to not be able to serve in this case? All right, now, do you remember anything about the jury instructions from the Judge Lucci case?
Just the same things you already said.
Okay.
And instructed us on whatever the law was.
Okay.
I don't-
All right, so if you're seated as a juror on this case and I read you the instructions just prior to deliberations, if you're listening to those instructions and you think that's not what Judge Lucci told me 10 years ago, so I can't be right, would you discount what he told you and listen to what I told you?
I would listen to you.
Okay, because I'm usually right and he was usually wrong, so but that's okay. All right. All right. And juror number 4, go ahead.
I was on the grand jury. Is that the same?
How long ago was that?
Probably 13 years ago.
All right. So you remember your job as a grand juror was to decide if there was probable cause to believe that a certain individual committed a crime, right? Okay. And if you as a grand juror voted for an indictment, that led the person then to stand trial, is how you understand it, correct? Okay. So we're at that stage where there was probable cause found and we're here for a trial. So you've got a different, if you're selected, you've got a different standard of proof, now proof beyond a reasonable doubt. Would you be able to perform that function as a trial juror with your experience as a grand juror?
I think so, but the sad part is, when I was on the grand jury, probably 80% of the cases were drug-related.
Right.
So I would be able to, but I'm just saying, you know.
Well, you know by the charges I read you, they're drug-related.
Right.
You don't know what the evidence is, obviously, because you haven't
Right.
heard anything. Would you be able to sit here, listen to the evidence, evaluate the evidence, listen to the law, and come to a conclusion based on the evidence in the law?
I believe so.
Okay. All right, who else raised their hand? Number 7, when did you serve?
1995, Ashtabula County Police Court.
All right, did you deliberate on a verdict?
Yeah,
All right. Criminal or civil case?
criminal.
Anything about that experience that would prevent you from being fair in this case?
No,
All right. Would you set aside everything you know about jury duty and your experience as a juror in that case almost 30 years ago and decide this case on the facts that you find in the law that I give you?
yes.
Okay. Anybody else in the box over here before? Okay. Number 20, when did you serve?
It was about 44 years ago. I was Painesville, criminal, and I was involved in the deliberations.
Okay. Was it in this courthouse?
Yes.
Anything about that experience that would cause you to not be able to serve in this case?
Not at all.
Okay. All right, anybody else? Number 34?
It was about 35 years ago. I served as a juror on 3 DUI cases, and I deliberated in all 3.
Okay. Which court was that in?
You know what, I don't really remember. Is there a traffic court or?
Yeah, it would have been one of the municipal courts, either Painesville, Mentor, or
It was Painesville.
Painesville? Okay, all right. Anything about those cases that would get in the way from you being fair to both sides in this case?
I don't think so, no.
Anybody else? Besides the people that have answered, anybody been called for this process but not been selected? Okay. All right. Is there, I'm not going to call on you individually. If this applies, speak up. Is there anything that irritated you about coming here, being questioned and not being picked? Anybody sore about that? All right. We try to be as efficient as possible when we're doing this, so just so you know that. Okay. All right. I know that juror number 1 had prior legal training, and I'm going to ask for others after I'm done questioning juror number 1 again, but I'll ask you to prepare after I'm done with juror number 1. I'm going to ask you if there's anybody who's got prior legal training of any type. So let's go to juror number 1. You were in the paralegal studies. Was that at Lakeland?
Yeah.
Okay.
Yes.
How long were you in that?
Probably a couple of years.
Did you ever work in that field after you finished the program?
No, I briefly worked in a law office as a receptionist while someone was on maternity leave, and that's all I really did.
Okay. Anything about your experience going through that program and then what you viewed in court that would prevent you from being fair to both sides in this case?
No.
Okay. Anybody else with prior legal training of any type? Okay. Does anybody, and I'm going to kind of group this all together, have any ethical, moral, religious, or maybe philosophical views that would prohibit you from sitting as a juror in this case? One of the issues in this case is, you know, it's a drug case, and one of the drugs that I mentioned was fentanyl. And you may know just by everyday life that fentanyl has a certain danger to it when people are exposed to it, and not necessarily taking it, but just exposure to it. As a result of that, we don't allow the drug itself to come into the courtroom. So you're not going to see the actual fentanyl itself, okay, because that poses a danger to everybody who's in here, all right? You're going to see photographs of it, you're going to hear testimony about it, but you're not going to see the drug in here, okay? If it were marijuana, you'd see the drug in here, okay, but we don't allow fentanyl to come in here. Is there anybody that would cause some difficulty because they would want to see the actual drug itself? Is there anybody who will not accept the testimony and photographs, if they're provided, of the drug as evidence in this case? And just so you know, there's no argument amongst the attorneys on either side in this case. They both agree to that, and they agree to it because that's the way it is. That's the order. Okay, we're just not going to let it in here. So, anybody at all have any difficulty with that issue? Okay. Now, in speaking with the lawyers before we came in here, it's expected this case will conclude by tomorrow. So I know that everybody has work obligations and or family obligations that they tend to on a daily basis, but other than those issues, is there anything that would prevent somebody from sitting here over the course of the next 2 days until this case is concluded? All right. Does anybody have any physical problems that would prevent them from sitting for periods at a time and listening to the evidence? And just so you know, it's usually about pretty close to an hour and a half that I always take a break. So there's going to be a break in the morning, break in the afternoon, a break at lunchtime, and other breaks as needed. So is there anybody that has any physical problems that would prevent them from sitting for about an hour and a half at a time? Now, as you've sat here, I've been talking to you for upwards of 40 minutes here. Is there anybody who's formed any opinion about how this case should come out? I'm always grateful that nobody raises their hand at that point, since you haven't heard any evidence, so. All right, now, as I said earlier in the instructions, it's your duty as jurors to decide whether or not the defendant is guilty of the crimes that are charged in the indictment. If he is found guilty, it becomes my duty to determine what sentence should be imposed in this case. And I make that decision with the benefit of much more information than is available to you in this case. Now, does anybody think they cannot perform the duties of a juror, that meaning determining whether Mr. Broadwater is guilty or not guilty of the charges, without concerning themselves of what might happen in the future if he is found guilty? Is there anybody who would be concerned and let that enter into their mind during the course of deliberations? All right. In a minute here, I'm going to turn it over to counsel to ask you questions. Counsel for the state, Ms. Linden, will go first, followed by Mr. Fatika for the defendant. And I want to remind you what they say or do in voir dire is not evidence. Evidence is all the testimony received from the witnesses, the exhibits admitted during trial, facts agreed to by counsel, and any facts I require you to accept as true. Since it is your duty to decide this case solely on the evidence as it's later defined for you, you must not consider as evidence any statement or act of any attorney made during the trial, including voir dire. Ms. Linden?
Thank you, Your Honor. Morning, ladies and gentlemen. If you can't hear me for some reason, if you raise your hand, then I'll know that you can't hear me. I'll try to be as loud as I possibly can, and I'm going to apologize if for some reason my back is to you at some point in time. Kind of unnecessary evil in the courtroom, things that we need to do. First thing that I wanted to address is the witnesses that we may or may not call, or names that you might hear during the course of the trial to see whether or not you know any of these individuals. And I would ask if anyone knows anybody from the Lake County Crime Lab. One of the individuals is going to be Kim Gilson from the Lake County Crime Lab. But anybody here who knows anyone who works there at all? Then we have, there are two names from Dollar General in Eastlake. I don't know if any of you frequent there or know anybody at that Dollar General. The two individuals' names that you might hear would be Tiffany Ho and Amber Ott. Anyone familiar at all with those names? And then from the Eastlake Police Department, I've introduced already Officer Eden. I would ask if any of you know any of the other officers from the Eastlake Police Department. Your number is 8?
Yeah, number 8. My cousin, his son works for, he was working for Eastlake Police. His last name's Homan.
Honan?
He might, right?
Go ahead.
No, he's with that force. At least he was last summer. I talked to the cousin. He's still with them.
Does he, or did he talk to you about any of his cases? Or?
I don't really see him. You know, so I see his dad, but I don't see him.
So would your relationship with him or with his dad, would that sway you one way or the other to listen to an officer testimony and either take their testimony as being more important or even on the opposite end?
I don't think so.
Nothing negative about that?
No.
And you feel that you could be fair and impartial listening to an officer's testimony?
I think so, yeah. Based on the evidence, yeah.
And that's what we're looking for here. Oh, yes, I'm sorry, juror number 19?
Juror 19, I know, I assume he's still Chief Larry Wright. I knew him, my previous career at the News Herald. I had a few professional dealings with him, doing stories. And then one of the jobs I had was covering the Lake County Captains, and I would see Larry just doing patrol duty at games or making appearances on behalf of the city at games.
Anything about that experience that would make it difficult for you to be fair and impartial in this case listening to? Officer Jacob Wright. I don't know if you're familiar with him at all.
Just strictly professional.
There are other officers from Eastlake that you might hear about as well. One of them is Gary Hotchkiss, Max Himes, and Chris Weber. I don't know if any of you are familiar with any of those names. Juror number 20.
Well, I have two things. When you mentioned the crime lab, I know that there were officers from my city that went there. I have no idea if they're still there. I don't, but I just wanted to mention that.
I appreciate that, thank you.
Yeah, because it just occurred to me. And then when you just mentioned Jacob, he was a part-time employee where I worked before I retired.
And where was that?
When?
Where was that?
Oh, City of Wickliffe Service Department. I didn't work with him, he was there working, but that's how I know.
Okay, did you have any personal interactions at all with him?
Other than if he had to come in and write up a report or something, no, they kind of did their thing, I was in the office and that was basically that. But I know,
Anything about that relationship that would make it difficult for you to be fair and impartial?
I don't think so at all.
Anyone else? When we talk about being fair and impartial, obviously we want to be fair and impartial to the defendant, but we would ask, the other issue is being fair and impartial to the state. We understand what our burden is, we understand what we need to do, what we need to present to, we need to prove. But I would ask if there is anybody here who, based on maybe personal experience or family experience, that feels that they would not be able to be fair and impartial to the state, especially in a criminal case where police officers are involved. Anybody who feels that they would have an issue with that at all? Okay. Can we all agree that each side should be given a fair shake to be able to present their evidence and have you listen to that testimony? The other issue is, when you hear about the drug in this case, is there anybody here who has had a negative personal experience in their lives with someone and the use of fentanyl? Okay, Juror 22.
You want to know the experience?
If you could, please.
My
If you feel comfortable. If you don't,
My
then
cousin passed away from it. My ex-husband's actually in prison for doing, I guess.
and I appreciate, I know probably not an easy thing to share, so thank you for doing that. Is there anything about that that makes it difficult for you to hear this case then, if it involves fentanyl? You feel that you'd be able to listen to both sides and be fair and impartial?
Absolutely.
Okay. So one other hand. Okay. Sorry, your number?
36.
Did you say 36?
My nephew died in December of that month.
I'm sorry, I just stepped down. I couldn't hear what you said.
So my nephew died in December of that month.
Oh, I'm so sorry to hear that. Anything about, you gotta say that's a difficult experience. Is there anything about that when you know that this case involves fentanyl that would make it hard for you then to listen to the facts?
No.
Do you feel that you could be fair and impartial to the state and the defendant?
No.
Okay. And why would that be? If you feel comfortable talking about that.
At least I can be fair.
Is there a reason for your hesitation though?
There's too much out there. That's too much fun.
So just the fact that it involves fentanyl, and it's a personal experience, would it be difficult for you to hear the case? And when I asked if you could be fair and impartial to both sides, you hesitated, and I just want to make sure that we're fair to the defendant, we're fair to the state. So is that hesitation something where it might be difficult then for you to listen to any testimony either against the defendant or for the defendant? Are there any other hands? Thank you. Number 5.
My stepdaughter passed away in 2019 from fentanyl, well, it's carfentanil. She was a heroin addict for difficult it is, and it's important to try to help.
And I sympathize, I'm sorry for each of your losses, I know that has to be difficult when you hear that. In this case, when we're gonna be talking about the possession of or the potential use of fentanyl, and then hearing that, did you feel automatically like, I don't know if I wanna hear this case?
No, I wasn't surprised. I know how, I mean, I don't think that there's a family that's untouched by drugs in this country at this point.
And you feel that you could be fair and impartial?
Absolutely.
Thank you. Anybody else? Back in the back? Your number again?
Sorry?
Your number is at 31?
Honestly, I can't be fair.
Is there an explanation for the reason why?
My son-in-law was involved in drugs, and he's a real smooth talker, and convinced everybody he was innocent of drugs.
And so, if
My
we,
ex-son,
I'm sorry,
my ex-son.
ex-son-in-law. Having that background, having that knowledge, and knowing the cases about fentanyl, would you be able to sit and listen to the testimony of each of the witnesses in this case and make a decision in this case based on whether or not the state proves its case beyond a reasonable doubt?
I could listen to it, but honestly, I can't. I've already reached. And that's just being honest.
No, I appreciate that. And that's what we're looking for. I think a lot of times people think when we're doing jury selection, it's a matter of like, who do we think the best jurors are for our side? And that's not the way it works. What we want to know is that you're going to give each side a fair shake. You're going to listen to witness testimony, and while they're sitting on the witness stand, whether or not you believe them or not, whether or not they present the evidence for us, for our charge, beyond a reasonable doubt. So I appreciate you coming forward and saying that, because that's what this is all about, is finding people that we know can listen, even if it's a difficult subject. I know probably a lot of you were really happy when you heard, because I know that there are a lot of responses. It's not a death penalty case, it's not a sex offense. So I know a lot of people that those are charges that cause some concern, so that is not involved here. In looking at your questionnaires as well, hold back for a second, can we all agree that there are some teachers, doctors, lawyers, police officers that maybe we don't like? Some that we don't like. Is there anybody here, and I know that some of you indicate that you don't like lawyers, and that's being honest, and we appreciate that. Is there anything about the fact that you're here and you're going to listen to two lawyers talk that's difficult for you, that you think, I don't want to listen to either of them? You're not going to offend me if you say yes. Nobody here who has an issue with lawyers. Okay, what about police officers? Since there are going to be police officers that are going to testify in this case, some of you have responded either very favorably, and there are a few that were negative about police officers. So I'm going to ask, is there anyone here that has an experience with police officers that would make it difficult for you to be fair and impartial in this case? Number 11? Yes.
I'll just say that within close family members, there's been some instances that have happened that I don't know that I did impartial. I'm sorry. Impartial.
Did that involve the Eastleigh Police Department at all?
No, it did not.
And did it involve any of the officers involved?
No.
The fact then that these officers are going to testify, even though you don't know the Eastleigh Police Department or those individuals, would you be able to sit and listen to them on the witness impartial?
Probably not, to be real honest.
I appreciate your honesty. And that, again, that's one of the things that we're looking for, to make sure that we have individuals that are fair and impartial.
Let me interrupt you here. Number 11, was there one instance or more than one instance that you had or a family member had with police that caused you concern?
More than that,
How many do you think?
I don't know.
All right.
I would rather not.
How long ago?
Let me say about 3 or 4 years.
Okay. Was it a department in Lake County?
Yes.
Do you obviously think that whatever the officers, whatever the department did was not justified? Is that accurate?
Yes.
And I don't want to get into the circumstances of what occurred, but do you believe that all officers conduct themselves in a way that's improper?
I never say never, and I never say all.
Okay. Do you believe a majority of them improperly conduct their business?
I would say that there are many that would not conduct business properly.
Okay. So are you telling me that if you sit here and you listen to a day and a half of testimony from what I presume are going to be 2 or 3 police officers, that you will discount what they're saying and not believe what they're saying because of your past experience?
I'm just saying, I don't know that I could not discount it.
Okay.
If you want me to be absolutely honest.
Oh, yes, I do.
I don't know that I can listen to them and say, yeah, I think they're telling the truth.
All right, thank you. Go ahead, Ms. Lemon.
Thank you. On the opposite end of the spectrum, are there any of you who have really good friends who are in law enforcement, whether it be security or as a police officer? Turn number 4.
I have a nephew that's a veteran police and one in the Lake County Sheriff.
And do you discuss any of their cases with them?
Well, whenever I see him, I'll ask the one of the men, I say, oh, what's going on in the city? He'll say a little bit.
Any in-depth conversations that you have about crimes that are happening in Lake County?
And the only one I asked him about was the shooting that was over by Home Depot, maybe 5 months ago. He just said that the witness didn't want to talk about it. I don't know if they pursued it anymore or not. That's basically the only one. Do you know which one I'm talking about?
I do. With the fact that you have relatives that are in law enforcement and that you've discussed cases with them, if an officer comes and testifies here, would you be able to judge them just as any other person out there in the community, just the same?
I think so.
And do you feel that you would give their testimony any more weight simply because they're police officers?
So,
And do you feel that you could be fair and impartial?
yes. Because when I was on the grand jury, there was a case involving a police officer against somebody, and we acquitted the defendant.
So you would be able to be fair and impartial?
Well, we didn't say the cop or the police officer had enough there, so.
And do you feel that if you could hold the state to the same standard, you're beyond a reasonable doubt?
Yes.
My brother is employed by Lake County Sheriff's Office as a deputy.
And same question to you, do you discuss cases with him at all?
Pardon?
Do you discuss cases with him
No.
at all?
No, he knows I'm here today, but
Is there anything about that, and if you were selected to be on the jury, either way that you would decide that would be difficult for you?
no.
Do you feel that you could be fair and impartial to both sides?
Yeah.
Thank you. Anyone else? Okay, sure. We're 39, okay.
Deputy Sheriff, a good friend of mine, I can be fair on the case, and we don't discuss cases.
Thank you. Okay, again.
Yeah, my daughter's been saved a police officer.
And you're number 31, correct? And is there anything about that relationship where you discuss cases?
Yeah, we didn't discuss it.
And based on that relationship, would you be able to be fair and impartial and listen to police officers testify and judge them just as you would anyone else? Number 7?
I'd rather retire from Grove City Police Department, currently works for Ohio Attorney General, developing curriculum for police academy, which supports it.
And does he discuss that curriculum or anything about that with you?
Discuss anything.
You never discuss it? Okay. On a positive or negative side, would you be able to be fair and impartial to police officers and hold them to the same standard as everyone else?
Yeah.
Number 8, my cousin's a retired police officer. My nephew was a police officer, and my son-in-law is a police officer down in Dayton.
Yeah, the whole family.
Oh, yeah.
Okay. Is there anything about that relationship with them that would make it difficult for you to be fair and impartial in a criminal case?
And so,
And would you hold police officers to the same standard as of any other witness? Number 13?
Yeah, my husband, is a retired police officer. He works with the evidence room now, so he's still in business, and my cousin is also a police officer.
Did you and your husband ever discuss any of the cases that he had? And in discussing those cases, did you form an opinion looking at police officers in a better light than other individuals? Without telling your husband?
Yes.
Okay. And so looking at the testimony of officers, are you going to give them more weight and more credibility based on your relationship?
Probably.
In listening to other lay witnesses' testimony, would you be able to judge police officers' testimony the same as you would any layperson, say someone who works in Dollar General?
Probably not.
So I guess bottom line, do you feel that you can be fair and impartial to both sides here?
I think mine is leaning towards the police. Whichever side they're on. I would lean towards it.
Okay, I saw another hand somewhere. Thank you. Okay, and here, and I know the judge touched on this briefly. I just want to make sure, normally, when you see TV courtrooms, there's a bunch of evidence that everybody parades in, right? And here, we're going to have photographs of the evidence, but not the actual evidence. So when looking at it, knowing the type of drug involved, is there anybody who's going to say, no, I really want to see all the real evidence up front, whether it be the packaging or whether it be the drug itself? Anybody who is going to require the state to actually bring those things into court? There's been a statement that I've heard several times saying, if it's not on video, it didn't happen. Heard that a number of different times. And here, if you have officers who don't have body cam and don't have dash cam, that's the department policy, is there anyone here who's going to have an issue with that? The fact that an officer doesn't have body cam, doesn't have dash cam at all? I know with technology, a lot of people require that now, that you will see some video here. But if it's not body cam and dash cam, no one here would have an issue with that? If you would, I could ask that you raise your hand. The other thing that I would address is there is an agreement by both parties about one of the videos is rather lengthy that we have to just the pertinent part about this case. Is there anyone here who is going to have an issue with that and say, no, I want to see the whole thing? No one? Okay. The CSI effect is kind of an older term, but with court TV being so prevalent now, have you all realized by now that this is not how it is on TV? A little different? Is there anybody here who doesn't realize that we don't solve crimes in an hour? It doesn't happen that way. Now you're going to hear from our Lake County Crime Lab, and you're going to hear about their testing. Anybody here who has any family, friends who do drug testing? Or work at any crime lab anywhere? If our crime lab person comes in and talks about the fact that they did some analysis on some machines and some drugs, but that they didn't put like something in the machine and then it popped out a photo of whatever the drug was. Anybody here who couldn't listen to the more lengthy testimony about the testing and accept that without maybe seeing the machines themselves? No one? Anybody here who wants to be a juror? Anyone? Anyone here who might want to be a juror? Okay. Number 20? 21? Anybody here who feels that that's just too much of a responsibility and they don't feel that they want to be here to judge that evidence? Can we all agree that every day we're judging different things, different people, and you have kids, you're judging whether or not your kids are telling you the truth or not. I know there's some concerns that were listed in the questionnaires about judging people and making that decision, or whatever your faith may be, that might make it difficult. So is there anybody here whose faith or beliefs would make it difficult then for you to come in and judge people, or judge the witnesses, make a decision about whether they're truthful or not? How many of you feel that you could do that? You could actually listen to each individual and make a determination, make a judgment based on that. Everybody could do that? All right, Judge, I have nothing further. Thank you very much.
Thank you. Mr. Fatika.
Thank you, Your Honor. Good morning, ladies and gentlemen. I appreciate your being here. We couldn't do what we do without your attendance on a rainy Monday morning. And special thanks, one of our potential jurors here is Karen's birthday. I don't want to single him out, but I want him to know that we especially appreciate that. Let's start out with presumption of innocence. You heard Judge O'Donnell mention that, but I'd like to hit on it a little bit more. Does anybody anticipate having an issue recognizing that as Mr. Broadwater is seated at the table, he's presumed innocent? Anybody have a hard time accepting that?
One in the back, John.
Oh, I'm sorry. I didn't mean to ignore you. I didn't see you. What's your number? 31? Okay. Can you, and number one, I appreciate responding. What are your concerns?
Well, I stated for my ex-son-in-law was on drugs and involved my daughter and grandchildren, and he was found innocent.
Okay.
I just think that highly unlikely that he wasn't on drugs, so I don't think I can.
Okay, so from your perspective, there's no way Mr. Broadwater could be not guilty?
I would certainly listen to all the evidence. I'll slightly change my mind, but right now I'm thinking he's got to do it.
Okay, so you cannot afford him the presumption of innocence, is that what you're saying, based on your life experience? Okay. Thank you, I appreciate you sharing that. Anyone else feel that way? Or feel like, well, something must have happened here. We have all these people from all over the county. The state has filed an indictment, so something must have happened, right? Anybody feel that way? Juror 22?
Yes.
Okay.
Because I know history and family history, I'm kind of impartial to it.
Well, what do you mean by you're impartial to it?
I know a lot of, like, the backstory, and
Okay.
a lot of his history and sister's history, and other sister's history, so.
So you're not starting with a blank page. And as Mr. Broadwater is seated at the table, you can't afford him the presumption of innocence. Is that what you're saying?
Probably not.
Okay. All right, I appreciate you speaking up. I saw another hand.
Because my nephew died.
What number, John?
My nephew died.
What number?
56.
Okay. Do you mind if I approach you only because I'm having a hard time hearing you?
My nephew died in East Lake, and I'm sure he knows him, or knew him, so I can't.
When you say you're sure, how are you sure?
Dead.
No, no, you said knows him.
He was very popular.
And because of your experience, you cannot be fair and impartial? Okay, yeah, thank you for sharing that. I know it's difficult.
One more, John.
Go ahead.
I guess I.
Number.
Your number, ma'am, I'm sorry.
I'm sorry, 13.
I should ask you that.
I figured if he was arrested, he probably did it, but I would be able to listen to facts, make them prove their case.
And I appreciate it. Your questionnaire, you referred to officers as the good guys. So we're not on equal standing as we stand here. You haven't heard any evidence, right? In this case. But your perspective is the officers are, in this your words, and correct me if not, my notes say good guys. And I appreciate that you can listen, but the presumption of innocence talks about your starting point right now. As you're seated there, as Mr. Broadwater is seated here at the table, he's presumed innocent. He's not presumed to be going against the good guys. He's presumed innocent. It's more about the starting point. Can you afford him that presumption of innocence, or as you look inward, is the reality that you cannot afford him presumption of innocence?
I tend to think something he did was wrong. Something he did was wrong. I can't say this.
Let me interject something here, John.
Thank
This is for the benefit of, in light of these questions of the whole panel. It was about 2 years ago, there was we were in this same situation selecting a jury. And about a week before that selection took place, there was a bank robbery in Menor. And they, of course, had a photo from a surveillance camera of the individual, looked to be about 6 foot, maybe 170, 180 pound white male with a baseball hat on and a blue lightweight jacket. So we were going through this questioning about the presumption of innocence, and one gentleman sitting in, I think, gentleman with a blue shirt number, I can't see your number, seated number 24 seat, said that, well, because the defendant was there, then he's going to presume that he did it or he wouldn't have been there during this trial, okay? And I said, well, that presumption applies to everybody. And I said to that gentleman, if you get charged with a crime, you're entitled to that presumption. And his response was, well, I wouldn't get charged with a crime because I wouldn't do anything. I said, all right, now, suppose you're released from this jury, this gentleman, you're about 6 foot, 170, 180 pounds, and suppose you were wearing a blue jacket and a baseball cap, which what the surveillance showed, and you walked out on the front steps of the courthouse, and Painesville police had a description of this bank robber, and they looked at you and say, this guy's 6 foot, 170, 180, he's got a blue jacket on and a ball cap. Suppose that officer stopped you, arrested you, and said you fit the description and charged you with the robbery, and you hadn't done it. And you were brought in here, and you were sat in that chair where the defendant is seated. Would you want a potential juror to say, well, you must have done it because he was arrested, okay? So I'm trying to highlight that there is a presumption that everybody's entitled to. And if you're seated in that seat properly or improperly, you're entitled to that presumption, okay? Go ahead, Mr. Fatico.
Thank you, Your Honor. Okay. Let's move on. The importance of presumption of innocence, why we're spending time on it, again, I appreciate Judge O'Donnell following up, or part of what makes it important is that the burden of proof is on the state to prove each and every element of the offense. Okay? In theory, at the defense table, we could sit silent and still prevail if the state of Ohio didn't prove each and every element beyond a reasonable doubt. Does anybody anticipate having a problem with that, with holding the state to its burden of proof? Show of hands. Juror number 4, you mentioned grand jury, your grand jury service, which again I appreciate. Do you anticipate having a difficult time making a distinction between grand jury service, which involves finding probable cause, which is a very low standard, versus guilt beyond a reasonable doubt, which is the highest standard that we have in the United States?
Well, like you said, when we're there, usually have the officer was there giving his side of the story. You don't have the defendant there to say anything. You're just trying to make a determination if there's enough evidence to go forward.
Okay.
I think in most cases we did a pretty good job on it. Like I said, I think we only did send 1, maybe 2 to trial.
Okay.
We hashed it over pretty good amongst us.
No, I apologize if my question implied that you didn't do a good job.
Right.
I'm more concerned with, there's a huge leap from probable cause to guilt beyond a reasonable doubt. And I just want to make sure that you're on board with being able to recognize that leap and the difference.
I think so.
Anything about your grand jury testimony that makes you feel like it's going to be more difficult for you based on the fact that an indictment was filed in this case to afford Mr. Broadwater the presumption of innocence that he deserved?
Well, I think there's a little more weight to what's going on here because now you're dealing with a person's life. That's something, you go to jail for a while or whatever. Over there, you're just saying, okay, yeah, moving on to the next level. Let those people hear the evidence and determine what's going on.
But even given your exposure to the grand jury system, can you acknowledge that as Mr. Broadwater is seated at the table, he's presumed innocent?
Yes.
Thank you. And again, I appreciate you speaking up. I know that it's difficult.
John in the back.
I'm sorry. Hi, number 35. Just for this disclosure, I was on the grand jury also 5 years ago.
Okay. you heard my questions to juror number 4. Do you anticipate having a difficult time making the leap?
I did tour the facility, where they do the drug testing and stuff. I understand what they do there.
Okay. Is any of that gonna cause you to be less than fair and impartial?
No.
And do you have any problem affording Mr. Broadwater the presumption of innocence as he's seated at the table?
I believe not. The only issue I would have is past practice.
Pardon?
This past practice, if that's brought up, it might deter what I thought.
Can you expound on past practice?
That he was already arrested and indicted as a drug addict.
Okay. And could you follow the judge's instruction not to do that and
I
just
could.
focus solely on the
I
evidence
just wanna be
before
honest
you?
that I
No,
would
no.
take that into consideration.
No, and I appreciate that. I don't want you, I'm asking a follow-up question, not because I don't appreciate your comment. I didn't think I feel like that. I feel like they need to hear about Mr. Broadwater's past history or hear from Mr. Broadwater himself at the trial. Anybody?
Hold on.
Yeah, I got it. You know, doing stuff like that right now sways your opinion.
Oh, yeah, you're number 4, I'm sorry. Go ahead. I wasn't ready for you.
Oh, okay. Hearing what he just said, you know, that could sway anybody's opinion now. Even though we're not supposed to
Well, here,
take it into account.
what you're doing here, if you're selected as one of the 12 and deliberate, is you're to determine the facts of this case, okay? The facts of this case, whether what's charged in that indictment, that the state has proven beyond a reasonable doubt any one or all of those charges. That's all you're deciding, okay? If there's information that goes to, and I don't have the slightest clue if there is or isn't, okay? If there were to be information that goes to his past, that is to be considered only for very limited and specific purposes, and you're going to be given instructions on that. But your charge is to figure out what happened here and make the determination whether, beyond a reasonable doubt, the state proved one or more of those charges, and that's it, okay? So I guess the question is, does everybody commit to doing that job and that job only? Or is the better question, is anybody who doesn't commit to doing that or cannot commit to doing that? And I know everybody comes into this, you folks were all picked at random from voter rolls. That's how you were picked, okay? So there wasn't, you weren't picked specifically for any type of case, one case or another. You're here randomly. You all have different backgrounds, you all have different experiences, but regardless of that, your charge is to determine whether the state proves their case beyond a reasonable doubt as to 1, 2, or 3 of those charges, okay? Go ahead.
Thank you, Juror. Before I know it's hard to speak up, and I appreciate you doing so. Would you agree with me that as you, or can you accept the judge's instruction that you could not hold Mr. Broadwater's failure to testify against him? So if he didn't testify, you're not supposed to consider that for any reason?
No. I think he should testify and give his side of the story.
Do you understand that he's got a constitutional right to not
Right,
testify?
I agree.
Okay, you agree with that right?
Yes.
All right. Does that right have any bearing if that right is ignored? And by ignoring, I mean if Mr. Broadwater decides for whatever reason, there could be 1 or 10 reasons he decides not to testify, if that's what he chooses, okay? Does that right mean anything if you automatically say, well, if I didn't hear from him, so I'm going to ignore that instruction that I can't consider it, and I am going to consider it? Does that right have any, does that right hold any water if that is how you decide the case and decide that issue?
I just, I don't know.
The natural inclination.
You know, if we didn't
Hold on,
hear
let-
just what was said,
Okay.
I would have no problem whatsoever.
Okay. Well, but what was said is not pertinent to what the jury's job is. Okay? Now, I think it's, by human nature, we all want to find out the most information possible about any given situation. Okay? If we walk out there and we see a car accident, as we're waiting in the crosswalk, and we look up right after the crash, once everybody's okay, you find out everybody's okay, you're going to want to find out what happened. Were you coming this way? Did you pull out? Everybody wants to know, as Andy Rooney used to say, the rest of the story, okay? But we're not on television. We're not in one of these stupid law programs on TV, okay? You're here on a very specific issue to decide a case based upon constitutional and statutory rights, and that's what you have to do. If we don't do that, then the system is in chaos, okay? So that's why, kind of at the beginning of this, I went through what your obligation is, okay, to decide the facts, to apply the law that I give you, okay? It's your sworn duty to apply the law that I give you. If you apply whatever the hell you want to apply, okay, then we don't have a system. We got the wild, wild west, okay? Then I'm Judge Roy Bean as I sit here, okay, deciding things on a whim, all right? So you may want to hear everything. You may want to hear more, okay? That's not unusual, all right? I've had plenty of chances to interview juries after a trial's done, and a lot of times they say, well, we wanted to hear about this, that, or the other thing. And I would tell them, well, this, that, or the other thing wasn't relevant to this case, okay? Their charge is to present to you relevant evidence. And I determine what's relevant and what's not relevant. If it ain't relevant, you ain't gonna hear it, okay? And you ain't gonna consider it because that's your obligation and your oath as a juror, okay? I'm off my horse, go ahead.
Thank you, Your Honor. Thank you, juror number 4, for speaking up. Like I said, I think it's difficult, but I agree with Judge O'Donnell. It's human nature. I think you just gave a voice to how a lot of other people are feeling. Now, having heard from Judge O'Donnell, does anybody anticipate not being able to be fair and impartial if Mr. Broadwater were to choose not to testify? Anybody? Anybody wrestling with the burden of proof is on the state of Ohio, and we and the defense do not have to present any evidence? Okay. Juror number 11, you indicated that you have a difficult time finding police officers credible. I'm paraphrasing, but.
At times.
Okay. You're the anti-juror number 13.
Sorry.
Thankfully, there's a buffer there. Thank you, juror number 12. As you sit here, and I don't mean to make light of it, can you be fair and impartial to the state of Ohio? From the standpoint that you don't know any of these East Lake officers, as I understand it?
No,
You don't?
I do not.
And you don't know anything about the case other than what the charges are?
Correct.
Can you keep an open mind and listen to all the evidence? Follow the judge's instructions?
I could.
Thank you once again. Nothing further.
All right, thank you, Mr. Fatico. All right, at this point, I'm going to excuse you to go out in the hallway, and when you get called back in, the 13 individuals that are chosen as trial jurors to hear this case will be identified. As I said, one of those 13 will be the alternate. You're not going to, nobody is going to find that out until just before deliberations begin, so I get all of you to pay attention. All right. So when you go out in the hallway, you can talk to each other about anything you want to talk about except one thing, all right? What we all just discussed for the past hour and a half, you can't talk about any of that, okay? So figure probably upwards of 20 minutes, we'll call you back in, pick the 13, begin with the witness testimony, okay? All right, now, as to the instructions. Evidence is all the testimony received from the witnesses, the exhibits admitted during the trial, facts agreed to by counsel, and any facts the court requires you to accept as true. Evidence may be direct or circumstantial or both. Direct evidence is the testimony given by a witness who has seen or heard the facts to which he or she testifies. It includes exhibits admitted into evidence during the trial. Circumstantial evidence is the proof of facts or circumstances by direct evidence from which you may reasonably infer other related or connected facts which naturally and logically follow according to the common experience of mankind. Direct evidence and circumstantial evidence are of equal weight. The evidence does not include the indictment or the opening statements or closing arguments of counsel. The opening statements and closing arguments of counsel are designed to assist you. They are not evidence. You are the sole judges of the facts, the credibility of the witnesses, and the weight of the evidence. To weigh the evidence, you must consider the credibility of the witnesses. You may apply the tests of truthfulness which you apply in your daily lives. These tests may include, but are not limited to, the appearance of each witness upon the stand, the reasonableness of the testimony, the opportunity to see, hear, and know the things concerning which they testified, the accuracy of memory, frankness or lack of it, interest and bias, if any, together with all the facts and circumstances surrounding the testimony. Applying these tests, you may assign to the testimony of each witness such weight as you deem proper. You are not required to believe the testimony of any witness simply because they were under oath. You may believe or disbelieve all or any part of the testimony of any witness. It is your province to determine what testimony is worthy of belief and what testimony is not worthy of belief. The testimony of a defendant is to be weighed by the same rules that apply to other witnesses if the defendant takes a stand and testifies. The defendant has the Fifth Amendment right to not testify in this trial. If the defendant chooses not to testify, you shall not consider that decision for any purpose. You should not decide any issue of fact merely on the basis of the number of witnesses who testify on each side of such issue. Rather, the final test in judging evidence would be the force and weight of the evidence regardless of the number of witnesses on each side of an issue. The testimony of one witness believed by you is sufficient to prove any fact. During the course of this trial, a number of exhibits and testimony relating to these exhibits may be introduced as evidence. You will determine what weight, if any, the exhibits should receive in light of all the evidence. Jurors will be permitted to take notes during the trial. Jurors will not be permitted to ask questions of witnesses. It is the responsibility of the lawyers to present all the evidence necessary for you to decide the issues in this case. You will not be permitted access to transcripts of witness testimony during your deliberations. Please be aware that once deliberations have begun, you may not have contact with anyone other than your fellow jurors and the bailiff. This means that once deliberations begin, you will not be able to make any phone calls. We will give you advance warning when we're getting close to the end of the case, so you may wish to let the necessary people know that you will be out of contact once the deliberations begin. You can be reached for emergencies, but if you are called out of the jury room, you will not be able to return. It's important that you be fair and attentive throughout the trial. Do not discuss the case among yourselves or with anyone else. Do not permit anyone to discuss it with you or in your presence. Do not form or express any opinion on the case until it is finally submitted to you. Wear your lanyard so the attorneys, parties, and witnesses know that you are jurors and off limits to them for conversation and contact. It may be difficult for you to understand why you may not discuss this case among yourselves until it is finally submitted to you. You will receive the opening statements, the evidence, the instructions of law, and the arguments of counsel. It would be unfair to discuss a case among yourselves before you receive everything necessary to reach an informed decision. You should explain this rule prohibiting discussion of the case to your family and friends. When the trial is over and your duty is complete, you will be released from this instruction. At that time, you may discuss the case and your experiences as a juror. I'm going to give you what's called the admonition. It's a standing court order that applies throughout the trial. I'll try to remind you at every recess of this admonition or a portion of it, but if I forget, it still applies. You've been selected as jurors in this case. We have taken the time to seat a neutral jury so this case can be decided based just on what goes on in the courtroom and not on outside influences. You are required to decide this case based solely on the evidence that is presented to you in the courtroom. It is my role as a judge to determine what evidence is admissible and what evidence is not admissible. It would be a violation of your duties and unfair to the parties if you should obtain other information about the case which might be information not admissible as evidence. You must carefully listen to all the evidence and evaluate all of it. Do not reach any conclusions until you have heard all the evidence, my instructions of law, and the arguments of the attorneys. Otherwise, you will have an incomplete picture of this case. Do not discuss the case among yourselves or with anyone else. The reason for this is you might be given information or an opinion that would alter the way in which you view the evidence or the instructions or even how this case should come out. Such an opinion or conclusion would be based on an incomplete or inaccurate view of the evidence and therefore would be clearly unfair. In addition, you must not try to get information from any other source. This ban on outside information also includes any personal investigation, including visiting the site, looking into news accounts, talking to possible witnesses, reenacting the allegations in the indictment, or any other act that would otherwise affect the fairness and impartiality that you must have as a juror. Finally, you must not have contact with anyone about this case other than me and the court employees. This includes viewing any social media sites of any kind regarding this case or any aspect of your jury service during the trial. If anyone tries to contact you about the case directly or indirectly, do not allow that person to have contact with you. If anyone persists in contacting you or speaking with you, that could be jury tampering, which is a very serious crime. If anyone contacts you in this manner, report this to me or to the bailiff as quickly as possible. You should know that if the admonition is violated, there could be a mistrial. A mistrial means the case is stopped before it is finished and must be retried at a later date. This can lead to a great deal of expense for the parties and for the taxpayers. If a mistrial were to be declared based on a violation of this admonition, the juror responsible could be required to pay the cost of the first trial and could also be punished for contempt of court. Counsel ready to proceed with opening statements?
Yes, Your Honor.
All right, Ms. Linden.
Your Honor, I move for a separation of witnesses and incorporate the indictment into my opening.
All right, both those are granted.
Thank you. In this case, the defendant possessed drugs. He brought drugs into the Eastlake jail and the next day then tried to escape from the jail. That's the information you're going to hear. And the witnesses that you listen to, they'll present testimony on that behalf. You're going to initially hear from Tiffany Hogue. She worked for Dollar General, works for Dollar General, and she had a number of customers that had come in and out, indicating that there was somebody outside on a building very, very close to Dollar General that appeared to be leaning against the wall. And she received some additional information that there might be a needle somewhere there, and so she went outside to look herself. As she was standing outside of the front doors of Dollar General, she could see the defendant leaning up against the wall and then laying down on the ground, and then getting back up and leaning against the wall and putting his head against the wall. As a result of what she heard from individuals that had come in and talked to her and her own observations, she then called the Eastlake Police Department. The Eastlake Police Department arrived on scene, and when they arrived, they were able to observe the defendant standing with his head against the wall and his hand against the wall, and took 2 photographs of him. You'll see those. When they approached, they noted that the defendant had a needle on the ground between his legs with his cell phone. That needle ended up being tested by the crime lab and had fentanyl and fentanyl-related compounds. Once he was taken into custody and taken back to the station, on the way, he was told several different times, if you have anything additional, you need to give it to me now, because once you take it into the jail, that's an additional criminal offense. He was told that on the way, he was told that when he got to the jail, he was told that when he was in the Sally Port, where the door comes up, car comes in, and then you go into the jail. When the defendant went into the jail, he was ultimately patted down. In his pocket, he had a folded up dollar bill. in that folded up dollar bill was fentanyl and fentanyl related compounds. He had taken that inside the jail after being warned not to. Defendant was then booked in. Next morning, Officer Eden allowed the defendant to go out to the sally port and have a cigarette. The door to the sally port was open about this far. And when Officer Eden backed up to go back inside watching the defendant decided it's a good time to run. Laid down on the ground and tried to get out underneath the sally port door. You'll even be able to see at some point the sally port door comes up a little bit. He's really trying hard to get out. At that point in time, he's been in custody. He's the responsibility of the Eastlake Police Department. You'll hear that Officer Eden really didn't have a choice. He can't put the door down to the sally port and crush him. He can't open it up because then he's going to run. So he then had to stop the defendant from leaving. Defendant really wasn't happy, wanted to get going. Two other officers had to come to assist. Those events and those facts are what you're going to hear. And at the close of the evidence, we will ask that you find the defendant guilty of possession of fentanyl, the illegal conveyance of the drugs onto the grounds of here, the specified governmental facility, being a detention institution, and then trying to escape the next day.
Tika.
Thank you, Your Honor. Good morning again, ladies and gentlemen. We touched on voir dire. We're respectfully requesting that you keep an open mind to incur all the evidence in the case. Hold the state to its burden of proof beyond a reasonable doubt, each and every element of the offense. We're going to ask you, as the prosecutor indicated, there are portions of the evidence that are on video. We're going to ask you to pay very close attention to those. I believe you're going to see a couple of pictures as well. But please, keep an open mind till the end of the case, till you've had all the jury instructions from Judge O'Donnell, and we're going to ask you to return a verdict in that case. Thank you.
Thank you. First witness.
Thank you, Your Honor. The state would call Tiffany Hogue to the stand.
Will you raise your right hand, please? Do you swear a testimony about gives the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
All right, have a seat right here. And please stay close so that microphone can pick up your voice, okay? Ms. Linden?
If you could first just introduce yourself. You do the jury, spell your first name and your last name.
TIFFANIEHOGUE.
And is Tiffany, and how do you say your last name?
Hogue.
Hogue. Can you tell us where you're employed?
Dollar General.
Which Dollar General? There are a lot more.
Timberlake.
Is the area where you're employed at Dollar General, is it close to Eastlake?
Yes.
Describe what you were explaining to me the other day about Timberlake and Eastlake and where the Dollar General is.
My side of where my Dollar General is Eastlake, but the other side of the street is Timberlake. But everybody calls it the Timberlake Dollar General.
But is that, here in Eastlake, Lake County, Ohio?
Yeah. Yes.
What do you do at Dollar General?
I'm the store manager.
And how long have you been store manager at that time?
Almost 2 years.
Have you worked at any of the other Dollar Generals?
The one in Surfside.
And how long did you work there?
About a year.
Now, as a manager, can you tell us a little bit about what your responsibilities would be at Dollar General?
Customer safety, training, answering any questions people have, ringing people up, stocking.
And do you have anybody else that normally works with you?
Yes. Amber. She is my assistant.
And what's her last name?
Ott.
And working at Dollar General, do you have a number of regular customers?
Yes.
People that come in on a pretty
Yes.
frequent basis?
Yes.
I want to talk to you a little bit about the reason that you're here, and take you back to September 16th of last year. Do you recall if you were working on that day?
Yes.
Where would you have been working?
At Dollar General.
No one in Eastlake?
Yes.
Okay. All right, now during the course of your work on that day, well, let's go back a little bit. What were your hours? How were you working that day?
Probably in the morning until 5 or 6 at night.
And was anyone working with you on that day?
Amber.
Did there come a point in time when something unusual happened outside of Dollar General?
Yes.
Can you
We
explain what happened?
We had several customers come in and complain that there was somebody up against a wall and he didn't look right, and he looked like he was on something. So I called the police at that time.
Were there any other concerns just other than him leaning against the wall?
One of my customers walked over and said that they saw a needle on the ground and said his wallet was on the ground.
You earlier discussed safety concerns.
Mhm.
Is this one of the things?
Yes, because there's a lot of kids that come in and out.
Where exactly was this person when you walked outside?
On the side of the building across the gravel parking lot.
Was it directly on Dollar General property?
I don't know if it's considered our property or not, but it's in between us and the plaza.
And for the record, I'm showing you closing counsel what we've marked for identification previously as States Exhibit 1A through 1D.
Thank you.
May I approach?
Yes.
So I'm going to hand you these exhibits 1A through 1D. I'm going to ask you to first look through them and then tell me when you're finished.
Okay.
I'm going to ask that you start with 1A and explain to me if you recognize, well, first of all, do you recognize those?
Yes.
Okay, and what are you holding in your hand?
Pictures of the store in the parking lot.
Let's start with 1A. What do we see in Exhibit 1A?
One side of the building with a couple cars, kind of the front door.
What about 1B?
The front door and part of the other building.
Okay, and 1C?
Pretty much the same as the other one, but front door and side of the building, some of the parking lot.
Okay, and 1G?
The whole side of the building with the parking lot.
And then looking at those, do you recognize those areas to be the Dollar General where you work?
Yes.
And do these fairly and accurately depict that area?
Yes.
In looking at those, were you able to see on any of these photos the area where this individual was leaning against the wall?
Yes.
I'm going to give you a marker here. I'm going to ask if you put an X. Tell us which photo first and put an X where that individual was.
1D.
So if you're on 1D, and this would be, what is this building where you have the X?
That's the laundromat.
So Dollar General, are you looking from Dollar General?
Mm-hmm.
Okay, so that's the laundromat area.
That's the laundromat.
This
Yes.
is the laundromat here?
Yes.
Your Honor, for the record, I'm showing opposing counsel it's been marked for identification. States Exhibit 2A and 2B. May I approach?
Yes.
Doing hand is marked for identification as States Exhibit 2A and 2B. those are?
Yes.
And what do you have in your hand
Pictures of the person that I called on.
there? And in relation to 1D, where you had showed me,
Mm-hmm.
is that the same area from 2A and 2B?
Yes.
And you say that it's the individual that you called on.
Yes.
How can you tell?
You can tell just by the back of him and the way he walks and stuff.
And did you recognize that individual?
Yes.
And how did you recognize him?
He was a customer.
I'd ask you some questions about did you have regular customers?
Mm-hmm.
Was he one of the regulars?
Yes.
And did you later learn what his name was?
Yes.
And what was that?
Matthew Broadwater.
And when you were able to go out and look at that individual against that building, where the laundromat was, and you're looking at 2A and 2B,
Mm-hmm.
what did you observe in comparison to what you're seeing in 2A and 2B?
He kept leaning up against the wall. It looked like he was honestly trying to make out with it. And then he would get down in the fetal position, and then he had trouble standing back up.
And how long was he out there? If you know.
Honestly, I don't know.
From the time that you first got some concerns from customers to the time you went outside, approximately how much time passed?
As soon as a customer came in and said something, we went outside.
And how long did you watch what was going on over there?
Probably about 5 minutes until the police came.
And from where you were in the store, I'm going to have you look at State's Exhibit 1, A, B, and C. And tell me if in any of those photos you're able to tell where you were standing to be able to see that.
Yes. In 1B.
If you could put a circle where you were standing. So I'm looking at 1B here. Are you able to see clearly
Yes.
through that area?
Yes.
Okay, do you know about how far away that is?
100 feet, maybe?
So once you observe that individual, and what was going on, what did you do?
Called the police.
Why did you call the police?
Because there was customers complaining about him, and he did not look like he was acting normal.
Were you able to observe any of the items that your customers had told you about that were on
No.
the ground?
No.
Not from where you were?
No.
Do you recall what number you called then?
The non-emergency line.
Okay, so you're familiar with the East Lake non-emergency line?
Yeah.
And how far away is Dollar General, East Lake Dollar General, from the East Lake Police Department?
Not even a mile, I don't think.
I'm sorry?
Maybe a half a mile.
Half a mile? So did the police then, did they respond?
Yes.
Okay, about how long after you called did they respond?
2 minutes.
When they arrived, was the individual male still there?
Yes.
And did you observe what the police did once they arrived?
No, I saw them walk over to him, and that was it.
This male that you saw that was a regular customer, would you recognize him if you saw him again?
Yes.
Did you see him in the courtroom here today?
Yes.
Could you please point him out, describe what he's wearing?
Gray suit,
And the
white
record
shirt,
reflect
maybe gray shirt.
it? Gray
White,
shirt?
yeah.
You're the record reflect the identification, right?
Yes.
And you say that you made a phone call to the East Lake Police Department, right?
Yes.
And do you recall, or do you know if that was recorded?
Yes.
And did you have an opportunity to listen to that recording?
Yes.
I'm going to show opposing counsel here what's been marked as State's Exhibit 3. May I approach again?
Yep.
So I'm going to ask you to take a look at State's Exhibit 3 and let me know if you recognize what that is.
Yes.
What is that?
The recording of the call,
How do you know that that's the recording from the call?
because I initialed it.
So your initials appear on that?
Yes.
And in listening to that, did that fairly accurately depict the call that you made on
Yes.
that day?
Yes.
Or at this point in time, I move to read that and publish this for the jury.
Any objection to 3?
No, Your
All
Honor.
right, it's submitted.
You won't need this just to call. You can put the lights up.
th, 2022, 10 hours, 43 minutes, 1 second.
Sean, no.
You have reached the City of Eastlake Police Department.
No. He does not need to get involved in that.
Eastlake Police, Zealand, how can I help you?
Hi, I'm the manager at the Dollar General in Timberlake, and there is a guy over here. I'm pretty sure he's on something. He is like making out with a wall and like banging his head and laying down.
Okay. Let's see. Hold on, I'm sorry. I got 2 calls back to back.
Oh, okay. You ready?
And then let's see
This is you. They're down the dollar aisle. I'm sorry, what did you say?
You're the 34600 Lakeshore, correct?
Yes. Yeah, he was on the side of the building this morning. He was on the side of the building this morning, too. I'm not sure what he was doing, but you can tell on his face he's not okay.
I'm sorry, 97156. What is your name?
Tiffany?
15697. Can you respond to Dollar General? 34660 Lakeshore. Manager on the phone advising. What's your last name?
Hogue. But he's trying to stand up now. He can't even stand. 440-552-7238.
All right, someone check it out.
All right, thank you.
Yep.
All right.
September 16th, 2022, 10 hours, 45 minutes, 1 second.
Okay, Ms. Hook, did that fairly and accurately depict the call that you made on that date?
Yes.
The dispatcher gave an address, the 34660 Lakeshore.
Yes.
What is that address?
The Dollar General.
And you indicated that on your call that from the look on his face, but I didn't seem right. Were you able to get close enough to actually see his face?
Kind of. I mean, you could see, like, his eyes were closed as he was staggering.
And you said that you saw him earlier on the side of the building.
Yes.
Did you see what he was doing at that point?
No.
When you first observed the defendant, he was leaning against the wall.
Yes.
And how long was he there leaning against the wall?
He kept, like, leaning and then walking, and then he would get down and then up again and against the wall.
So he was mobile.
Yes.
And did you see him again that day after that?
No.
After the police came?
No.
I think I have nothing further this time.
Thank you. Cross-examination?
Thank you, Your Honor. Good morning. morning, Ms. Hogue.
Good morning.
Am I pronouncing that correctly?
Yes.
When did you first observe Mr. Broadwater on September 16th, 2022?
I don't know the time. It's just when customers came in.
Okay. Well, if we use your phone call to the police, I believe it was at 10:43.
Okay.
So, again, I understand you don't know the exact time. How much prior to that phone call, or how many minutes went by before you called?
Maybe 5 minutes.
Was that the first time that you saw Mr. Broadwater that day?
No.
When was the first time you saw him?
I think it was before we even opened, so before 8 o'clock.
And did you ever see him walking a cat or a number of cats at any point during the course of the day?
Cats? No.
Did you, when you saw before you opened, anything seem unusual at that point?
He still seemed kind of off, but nothing horrible at that point.
Okay. Certainly nothing alarming to the
No.
extent you were comfortable. When you observed him next to the building, we'll say around 10:40 that morning, when you first went out after the customer complained, what did you say?
Him up against the building, staggering, trying to,
And about how far away were you?
probably about 50 to 100 feet.
And you mentioned on direct that it seems there was something unusual.
Yes.
And was it your sense that he was impaired?
Yes.
And as I understand, he was walking, leaning, and then in a fetal position?
Correct.
Is that your testimony? Any inclination to call for medical assistance based on that behavior?
I mean, I just called because he wasn't acting okay.
I understand that, but was there any consideration given to calling for medical assistance based on that, based on the behavior that you observed?
I mean, I'm sure he needed some medical assistance.
Okay. And did you at any point see an ambulance or anything come to
Just police.
just, and
Yes.
how many police cars?
2 or 3, I don't remember.
2 or 3?
Yes.
Okay. But no EMS, no ambulance, nothing like that?
Not that I remember.
And as I visualized from your testimony on direct, once the police got there, that kind of ended your involvement?
Yes.
Did you go back inside the store?
Yes.
One moment, please. Thank you very much.
All right, any redirect?
Yes, Your Honor, thank you. So, when you saw the defendant outside, did you know whether or not he was drunk?
No.
Did you know if he was high?
No.
In terms of hearing that there was a needle there, did
Objection.
that come into consideration?
Overruled.
Yes.
And were you close enough at all to see how impaired he was?
No.
Did you know if he was tired?
I mean, no, but no.
But you were able to call the police department to respond?
Yes.
And you felt that that was the appropriate thing to do at that point?
Yes.
May you recross?
No, thank you, Your Honor.
All right, you may step down, thank you. All right, next witness.
Thank you. And state would call Officer Cole Eden to the stand.
You raise your right hand, please. You swear a testimony you're about to give us the truth, the whole truth, and nothing but the truth, so help you God. All right, have a seat. London?
Thank you, Your Honor. Officer Eaton, if you could please first introduce yourself to the jury, spell your first name and your last name.
My name is Patrolman Cole Eden, Coleeden. I've been employed with the City of Eastlake for over 24 years now.
And what capacity have you been employed there?
Police officer.
Tell me a little bit about what training you went through to become a police officer.
I went through the academy. After the academy, I went to Eastlake. Then I went out to Lake County, Ashtabula County Narcotics. I worked out there 3 years undercover, and then came back to the City of Eastlake.
And when you were with Ashtabula County Narcotics Undercover, what capacity were you, police officer there?
Yes.
And when did you become a certified police officer in the state of Ohio?
June 23rd, 1998.
During the course of that time that you've been a certified police officer in the state of Ohio, have you received any training at all regarding narcotics?
As far as, yes, I mean, after I left the academy and went out to Lake County, or Ashtabula County, we had multiple classes at Opata.
What kind of classes?
We went to, it was a meth lab class on how to take apart methamphetamine labs. That was held at Quantico. We had multiple other classes for cocaine, which was real big in the early 2000s.
Any other training regarding fentanyl and all related compounds?
No, not through narcotics, no.
How about through working through Eastlake Police Department?
Yes, with the amount of, we've had classes at the station, but most of it is don't touch it, don't mess with it. With the amount of carcinogens and everything else in it that's terminal to people, we don't monkey with it.
And in terms of handling it, is there any special procedure that you follow to handle any kind of drug these days?
Yes, if we pick up any sort of substance that we don't know what it is, actually any narcotics, we'll pick it up wearing a rubber glove, and then we'll just take the glove off and turn it inside out and place it right into an evidence bag, seal it up, and ship it off to Lake County Crime Lab.
And in terms of working with Eastlake and with the narcotics agency, how many times have you come in contact with, let's say, first of all, heroin?
Quite a bunch.
More than one?
Oh yeah, over 100.
And what about dealing with cocaine? You mentioned cocaine.
Quite a bit, again, over 100.
And what about fentanyl-related compounds?
Fentanyl's mixed into everything now, so it's with it. It's in we found it in cocaine. It's in heroin. It's in meth. I mean, it's in all sorts of narcotics.
So you find on a pretty regular basis?
Yes.
And through the course of your work, have you encountered individuals who have used heroin, cocaine, or meth?
Yes.
In observing those individuals, are the responses to those drugs always the same with everyone?
Each person's different, but yes, 99% of them, yes. They're all the same.
And have you come in contact with individuals who have recently used fentanyl?
Yes.
What do you typically see when you see someone who knows under the influence of fentanyl?
They're sleepy, groggy, lethargic. They're cooperative most of the time. They're not combative. They're just there.
And in your training and experience, have you had training to be able to distinguish whether or not someone should go to the hospital?
Yes, if it gets to a point to where they absolutely need to go to a hospital, we'll advise a supervisor. If it's something that's above what we think is of the normal use or intake of each individual, we'll let the supervisor know, and then the supervisor for the shift will make that decision.
Is it uncommon for you to have individuals that you place under arrest and bring to the jail that are under the influence of something?
No, it happens quite a bit.
And so approximately how many times, say in any given month, do you encounter that?
Somebody under the influence of any substance, quite often. Probably 70% of the people we arrest are under some sort of substance.
Let's talk about this particular case. I'm going to direct you back to September 16th of last year, 2022. Do you recall on that date you had been working?
I was working.
Okay, what shift and hours would you have worked that day?
I was day shift, 6 a.m. to 6 p.m.
And what was your duties and responsibilities during that shift?
Regular patrol. I mean, from whatever dispatch gives us, we'll go handle.
Do you have any particular zones that you're assigned to, or is it just the whole city?
There are zones, but I believe I was a city car.
What does that mean?
I have the entire city. Like, I'll just float around and work the whole city. The other two cars would work the north and south zone.
And how would you have been dressed that day?
In full uniform?
Kind of like you are today?
No.
Okay, what would be different?
I would have my vest on, a portable radio, multiple sets of handcuffs, my duty belt.
And what would we say if you had your duty belt on, not here in the courthouse, but normally, what would you have on your duty belt?
My duty pistol, set of magazines, a taser's on my gun belt, and then on my vest, I have my portable radio, set of cuffs, tourniquet, pens, handcuff key.
And during your patrol that day, would you have been in that uniform and in a marked patrol car traveling around the city?
Yes.
Do you recall if anyone else was working with you on that day?
Officer Gary Hotchkiss, who was training Jacob Reich.
Is that unusual to have somebody in training with another officer?
No, that's the way we do training. One of the field training officers will have one of the trainees with them while they go through their process.
Did you have the same kind of procedure when you started with these sites?
Yes.
During the course of your work that day, then, did you receive some dispatch to respond to a call at Dollar General?
We did.
Can you tell me what the nature of that call was, please?
Dispatch put it out that there was a male making out with a brick wall at the Dollar General on Lakeshore, which would be the 34660 address, and it was up against the laundromat wall.
And what did you do when you heard that information?
I responded to that location, and as I pulled in, I observed the two ladies, later to be known as the managers, and they were pointing to the south end of the lot. Because as you pull in that lot, you're on the west side of the building. They were pointing to the south end, so as I turned the cruiser and started to face south, I could see Mr. Broadwater up against the wall.
This Dollar General that you're talking about, this is in East Lake County, Ohio?
Correct.
And the other side of the street?
Is Timberlake.
So it's a different jurisdiction there?
Correct.
Thanks. May I approach your honor?
Yep.
Okay, just for mark identification, states exhibit 1A through 1D. I'm going to ask you to look at those and tell me when you're finished, please.
Okay.
And do you know what those are?
Yes, that's a Dollar General at 34660 Lakeshore. And the brick wall on the west side of the photograph is going to be the east end of the laundromat.
Okay, so we're looking at 1C.
1C, these doors actually will face north-northwest.
You could put in just an N or NW by those doors so that the jury can see which way they're. And for me, I'm not great with.
It's understandable.
And so when you pulled in, which side of the building would you have been on?
So we would have been on the northwest side as you pull in the parking lot.
Do you have a photo of that area?
Not really. So as you pull in, you come in from here, which then faces 1A, which then will face, as you turn south, you will face south down in between both buildings.
And if we're looking then at State's Exhibit 1D, are we seeing that area you're talking about?
Correct.
So you're facing which way on that?
This is facing south.
Okay, so that must be, 1D would be facing
South.
If you could then just indicate on there with a circle where the individual was.
Sir, well, it's right where the X was, where Mrs. Hoag put it.
Okay. So if we look at that, this is where you saw the individual.
Correct.
And the photo that we see here, is this approximately your first vantage point of what's going on?
Yes, as you pull in the lot, yes.
Grant, this time I'd ask to move to admit State's Exhibit 1A through 1D and ask to publish them to the jury.
Any objection?
No, Your Honor.
All right, they're admitted.
When you arrived on scene, who did you arrive with, if anyone?
Officer Hotchkiss and Officer Reich were shortly thereafter, right behind me.
When you arrived, where did you go?
I pulled up just short of Mr. Broadwater in the parking lot. I think my cruiser was just into the gravel lot. I stopped, got out. I took a picture of Mr. Broadwater and then walked up to him.
When you initially got there, what did you observe about Mr. Broadwater?
I observed Mr. Broadwater. He was facing the building. I mean, it's in the picture. And he had his face squarely planted on the building.
I'm going to hand you Exhibit 2A and 2B. Just ask you to look at these. Do you recognize them?
Yeah, it's the picture I took.
So you specifically took those?
I did.
And do they fairly and accurately depict the first observed from Mr. Broadwater when you arrived on scene?
Yes.
What did you do when you saw this?
I approached Mr. Broadwater. I called him by name. And then as I walked up, I saw the needle between his feet. I placed him into handcuffs right away. I didn't know if he had anything else on him that was sharp. Advised him he was under arrest. And then I patted him down real quick for weapons. There was no other weapons or anything on him. I advised him a second time that he was under arrest. Placed him in the back seat of my police car. Officer Hotchkiss and Officer Reich were there, and we searched the area. I asked Officer Reich to go get an evidence bag so we could pick up the needle. and his phone and his wallet. We placed all those into evidence, and then we obtained statements from the managers.
So when you talk about what was observed there, you mentioned a wallet. Whose wallet?
It was Mr. Broadwater's.
And you mentioned a phone.
His phone was on the ground, yes.
And you said a needle.
Yes, right between his feet.
This may seem kind of silly, but if you could describe specifically what you saw.
The needle was laying between his feet. I mean, it was empty, but you could see there was still residue in it, suspected to be heroin. There was a little bit of blood on the needle itself. His cell phone was just in front of his foot, his right foot, as he faced the wall. And his wallet, I believe, was off to the right of him. I don't remember how far.
Anyone else around him? Anybody else outside there?
Nobody.
And if I'm showing opposing counsel exhibit 4A. Matt Roach?
Yep.
I'm going to show you what's been marked as exhibit 4A and ask if you recognize what that is.
Yes, that's the needle in the Sharps container that Officer Wright put it in.
Now, originally, was that in a Sharps container?
No, it was just laying on the ground, right in the dirt.
Did you look, or how were you able to look and see that there was some sort of residue in it?
I picked it up with a glove from the end, the plunger end of it, picked it up, and then we placed it into a Sharps container. So at that time is when we noticed it still had a little bit of residue in it.
And have you seen needles like that before in your training experience?
Yes.
When do you see needles like this?
It's for, they use them for injecting narcotics. They also use them for injecting people who are diabetic, so they're readily available.
And what was it about this scenario that led you to place Mr. Broadwater under arrest?
For the possession, for the needle.
And when you were up talking to Mr. Broadwater and you were placing him in cuffs, describe his demeanor to me, please.
He spoke actually very clear. He wasn't really slurring his words, but his movements and his ability to maintain his balance were off. Like his movements were very jerky. They weren't smooth. Nothing was fluid. He took a couple steps. I grabbed him by the arm just so he didn't tip over. But I mean, otherwise, he spoke very clear.
Have you seen any individuals in your training experience with similar characteristics?
Yes.
And when do you normally see those similar characteristics?
After somebody's used some sort of narcotic.
Did it appear to you, based on what you were observing, that there was a need to get him to the hospital immediately?
No. Otherwise, I would advise the supervisor.
So what did you do then after you placed him in handcuffs?
Placed him in the handcuffs. Again, I searched this person for weapons. I placed him in the rear seat of my police car, Unit 866.
What did the other officers do that had arrived on scene?
They started searching the area to make sure there was no other needles, since it is a public place and there's kids in and out and running around. We didn't want to leave anything for anybody else to find and end up hurting themselves on. So we searched the area with no results, and then I asked Officer Wright to obtain statements from the store managers.
And that was
Yes,
Tiffany Hope, who was just here, that's one of the store managers?
correct. Officer Hotchkiss and I spoke to her after we were done with Mr. Broadwater.
You referenced Mr. Broadwater. Do you see that individual in the courtroom here today?
Yes, he's sitting in a gray suit at the end of the table.
And the record reflect that with the commissioner?
Yes.
When you got in the patrol car with Mr. Broadwater, the defendant, did you have any conversation with him?
I did. I have a conversation. Actually, I had it with him prior to leaving. I opened the back door up, and I do it with all the prisoners now that we arrest. I've been doing it for a couple of years. I ask him, you have anything on you that you're not supposed to have, illegal narcotics or substance? If you bring it into my jail, I will charge you with it. Mr. Mr. Broadwater stated he didn't have anything on him. I said, okay. I closed the door, got back into the car, and headed back to the station. I asked him again, I'm like, if you got anything, just let me know. It's easier to deal with it now than if you bring it into the jail. He's, again, said he had nothing on him, backed into the Sally Port. I had dispatch closed the garage door because there's no controls in the garage, in the Sally Port for us to use. I asked him again when I opened the door, it's your last chance. If you have anything on you, let me know. And he said no, he was good. I opened the door, I escorted him into the jail. I unhandcuffed him, told him to have a seat on the bench, and started the paperwork. And then when Officer Hotchkiss and Officer Wright came back to assist in the booking process, I searched Mr. Broadwater's person again, and I found a small dollar bill folded up containing suspected heroin, is what we thought at the time. We didn't have the lab results on.
Okay, so when you're doing the initial pat-down, why is it that you didn't find it then?
We're just looking for knives, guns, you know, large items like that. If you're going to be under arrest, we'll take you in and do a more thorough search of your person. But at that point in time, it's for their safety and for officer safety to make sure that they don't have anything on them. They can stick, cut, or poke, or shoot.
And other than the needle that you saw at the scene, there wasn't anything additional?
Correct.
And in terms of there being, I mean, it's not unusual for people to have money in their pockets, right? I mean, you see people with money in their pockets all the time.
Yeah, it's getting less and less. More people are dependent on their debit card, but yes, people do have money in their pockets.
So what was unusual about this particular dollar bill?
This one was folded up real small, and it contained a powder. And once we saw that, Officer Hotchkiss, because when I found the dollar bill, I handed it right to Officer Hotchkiss. Officer Hotchkiss started to unfold it gently, saw it, and he goes, no, we're not opening it in here. So then he just took his glove off, wrapped it up, and then we placed it into an evidence bag so it'd be secure.
When you originally did the search and you found the dollar bill, did you have gloves on?
Of course.
And then when you handed that dollar bill folded off to Officer Hotchkiss, did you both have gloves on at that time?
Yes,
And you said you originally thought maybe it was heroin,
correct,
but you later learned it was something else after Joe went to the lab.
correct.
Your Honor, for the record, I am showing the opposing counsel what I have marked for identification as State's Exhibit 4D, E, F, and G. May I approach?
Yep.
Been handed by mark for identification as State's Exhibit 4D, 4E, 4F, and 4G. Do you recognize those?
Yes, that's a dollar bill with Officer Hotchkiss's glove when he pulled it off. Obviously, the lab opened up that dollar bill because it wasn't like this when we put it in there, but they put it in their bag when they opened the dollar bill to test it.
So, the way that if the dollar bill kind of looks like this inside here, show me how it was folded inside the pocket.
It's folded down close to that size.
Okay, so
So if you open it this way, and the ends are folded in. That way, anything they have in the ends won't slide out or dump out, so they're not losing their product in their pocket of their illegal narcotics. So then if you open the ends, and you open this, then you can see what they have folded up in there.
so when you originally observed it, it was in that kind of small.
When I found it, it was inside his waistband in his shorts in that small, useless change pocket that they put in there.
Okay, so when I'm talking about in pockets, it's not
It's not an outside pocket. I could feel it through his gym shorts, and it was on the inside change pocket.
Okay,
That-
so around his waist, there's a pocket inside that?
Correct,
And that's where that was?
correct.
So when you open it up, like you were showing us what the ends open, is that how you were able to see what was inside?
Officer Hotchkiss opened it, yes.
Why did you immediately give it to Officer Hotchkiss and just get hold of the fellow though?
Because that's normally, I mean, in past practice, that's the way most people carry their illegal substances. So I handed it to him because I didn't want it, Mr. Broadwater to act up once I found it, and I didn't want it spilling all over the jail, becoming airborne for him or us.
So when we're looking at State's Exhibit 4, this is this one, 4D,
D.
what do we see there?
It's the dollar bill with Officer Hotchkiss's glove and the product, but it's in Lake County Crime Lab's bags now.
So originally then, the bag that's at the bottom with the substance in, where was that?
That was in, the bag wasn't there, it's just the substance, just the powder was inside the dollar bill.
And then if we look at the next exhibit, 4E,
They flipped the bag over. It's the same bag containing the same dollar and the same glove, but they've just flipped the bag over to take a photograph from the other side of the bag.
what about F and G, where are those?
That looks like a close-up that the crime lab took of the smaller bag that's inside containing the narcotics.
And that would be the front of that?
That's the front of it, and then the other one would be the back of it.
And in looking at those photos, do they fairly and accurately depict the evidence that you obtained on that day? Now, not in the plastic bags from the crime,
Yes.
but the actual substance and bill and glove?
Correct.
So after you located that in his waistband and handed it over to Officer Hotchkiss, what did you do then?
We finished the booking process to finish booking Mr. Broadwater in.
How long does that process normally take?
An hour, pretty close. We were training Officer Reich, so it probably took a lot longer. I mean, the paperwork and the computer work and everything is quite extensive.
Now, in that, well, I'm gonna go back. On your uniform, you did not mention any kind of camera, body cam on your uniform when you described your uniform before.
Correct.
Does your department have body cams?
We do not. We don't have body cams or car cams.
You also described something, a sally port, and maybe some of us know what that is, but if you could describe so that we have a better understanding of what exactly that is.
Sally Port's the garage, basically. It's a one-car garage, and it's attached. There's only one door in, the garage door, and then there's a man door that goes into the jail. So when we arrest somebody, we back our cars in, have dispatch close the garage door, so now we're inside. But this way, when you back in, if you open the car door, it leaves them only one way to go into the jail. So you don't have to fight with people. You're not having to go hands-on. You can just escort them right in. And if they're intoxicated, be it any illegal substance or alcohol, you can just kind of guide them in using the car door and help them right into the jail. You go into that leads right into the booking room, and then we just close that door so they don't have access back out to the Sally Port.
And do you know in that area, that booking area, if there is any way that anything is recorded in that area?
It's recorded in the Sally Port and in the booking area.
And when someone comes into the booking area, are we able to see then what occurs?
Yes, it's all recorded, video and audio.
Your Honor, for the record, I'm showing the opposing counsel States Exhibit 8. May I approach?
Yep.
I can hand you it to Mark, the States Exhibit 8, ask if you could take a look at that and let me know when you're done.
Yes, that's the disc with the recording, audio and visual of the booking room. I believe it is. It's got my initials on it.
So when looking at that before, did it fairly accurately
Yes.
At this point in time, I would move to admit this booking clip and publish this for the jury.
Any objection?
No, Your Honor.
All right, it's admitted.
Non-smoking facility. Well, smoking's bad for your health. I mean, not that it's gonna make you any more or less intelligent, but. Right? Smoking, it's not gonna make you any less intelligent than what you already are, right? How old are you? 33. 33? Sure. You are an awesome person of society there. 33 years old, I mean, you are just fucking helping society out all the way around. Yeah. Right? What's your social, you know it? Yeah, it's 282. Matt, 282 90 00. Matt. Yeah, I'm answering. So that's 059 282 90 282 9000. Oh, that's just fine. Good, sir. 00. we just get show you before we get started. The first two things we gotta put in the book. Yeah, see the book. Double check to make sure I know he already started some of this, but. Alright, so book, and then the computer. Okay. Same thing as with the OV. Start at the top. That way you don't miss anything. Or you said, I'm sorry. I was thinking because with it like that, I don't care. I mean, we can all go there and just do a print and everything. Or just what do you want? That's what I was saying. I didn't know, but if you wanted him to do it from start to finish so he knows how it goes. Sorry, I'm more concerned with it. Hope so. Going all right. Yo, bro! What are you doing? Nothing, just checking on you. Yeah. You got anything on you shouldn't have? Give me your tennis shoes. Take those off. Yeah. That's a good one. Bro. Just set them right up there. Matthew, what city were you born in? Gainesville. Yeah, I'm gonna search you real good. Put your hands up on a wall. Nothing is gonna cut, stick, or poke me? No, sir. Promise? Listen. Man, what's the take, man? What do you want? Yeah, you... No. You're just high on life? I'm not high. I'm just pulling my girlfriend's kittens for a little bit. Where are the cats? They're in their cage. Where at? The cage that you had when I was freaking waiting for the puppy. There's no cage with kitties in it, bro. You know where I arrested you at? Yeah. Where? Right by convenient. Kind of, yeah, close. Hold up. No. Do you wanna, roll my socks? Yeah, maybe in a minute. Deal, bro. Yeah. Hang out there for me. Yeah. No. Smoking's not good for you. Stunts your growth, but I mean, it's not going to hurt your intelligence, but... Alright, sit down. Is there one?
Sorry, it's a disc. Not sure why it's not playing from here. I don't know what's happening. Sorry, let me see if. Stop. Sounds like it's trying to.
All right. Officer Eden, what are we going to see in the remainder of this while I couldn't try and get this going? Sorry about that.
We're just going through with Officer Reich on the rest of the booking process.
Okay, so Officer Reich, where is he located in this?
He's the one standing in front of the computer. He's going to be the one closest to the step going into behind the booking counter. He's much taller than Officer Hotchkiss.
Let me turn it off for just a second. I have a different way to play it. Okay, I'm gonna try it.
All right, can you guys approach a minute? All right, ladies and gentlemen, I'm going to send you to lunch. Remember not to discuss the case among yourselves. Don't try to find out any information from any other source, and do not come to any conclusions until the case is submitted to you. So why don't you be back at about 1 o'clock. We'll get started as soon as everybody's ready. Okay?
All right, so jury, you can leave those here and bring them with you in your, I should come to the jury room first, give you some instructions, and I'll let you go.
It's great when technology works.
Call Lindsay, see if she can figure it out.
That's funny since she's not there anymore.
All right, I'll see you in an hour.
Thank you.
We can go to lunch.
Over. You need anything?
See if this flash drive will work to play this.
You need anything?
Nope.
Good.
Yeah, I'm gonna walk back to the office since my phone is sitting in my coat pocket that I left there.
Yeah, run over and see Mrs. Khan. Let's see what she's got going on over there.
Thank you, sir. Yeah, I'll be back.
Okay.
Back to the office.
Seriously? Okay. I was worried about that, so.
Yeah.
So
They
thank you. Do you, well, where'd you go? I don't want to pull, no, where did he go? I don't want to pull up.
Oh.
This must be. I'll have to ask him.
call you this.
I don't want to go through all your things. I saw.
Those aren't my fault. No, they were sitting there when I walked up. I might acquire them, they got no initial, and they're white. Yeah, dude. They're still the old ones. What kind of ones? $10. Matt, you wanna tell us what the brown powder is in the dollar bill? Nothing? Cause I'm gonna charge you with bringing it in here, cause I asked you in the car if you had anything on you shouldn't have. And it was gonna be a felony if you brought it in here, so I'm gonna whack you with that too. Well, I'm charging with it anyways. Just tell me what it is. I'm saying I don't know what it is. You don't know what it is?
So in reviewing the video, I'll just ask you, is it unusual for people when buying drugs, do they automatically just always tell you what it is?
Sometimes.
Sometimes maybe not.
Objection.
Overruled.
And for the record, I'm showing opposing counsel to the mark identification states exhibit 8A, 8B, and 8C. May I approach?
Yep.
In here, it's been marked identification states exhibit 8A, 8B, and 8C. Do you recognize what those are?
That's me patting down Mr. Broadwater.
Those photographs, where do they come from?
That's taken from, it looks like a still shot from the video from the booking room.
So the first one, you said that was 8A, that's patting down?
Yes,
Okay, what is 8B?
same thing, searching his person.
And when you're checking in his pockets, you don't find it there, you find it in the waistband?
In the small pocket in his waistband.
And then 8C?
8C is when I pulled the dollar bill out and handed it to Officer Hotchkiss.
When you were speaking to the defendant, either in the car or even during booking, did he appear to understand what you were saying?
Yes,
Did he respond appropriately? Not meaning that he said what you wanted him to say, but did he respond appropriately to questions that were asked?
yes, he said he did not have anything else on his person.
And he was advised that he was not permitted to take anything into jail.
Correct. I make that clear with everybody that we arrest if I'm there.
There's no special dispensation where you didn't bring drugs like that in?
No, none.
At one point during the booking, you told him to sit and don't go anywhere. Why did you just leave him sitting there on the bench?
We have to go get our paperwork, the leads, the criminal history paperwork, everything from dispatch. They don't have the ability to print it in the jail because there's other people that are not lead certified back there, so we have to go to dispatch, pick that up, and then bring it back for the information for the booking.
Okay, so when we're looking at, I'm just gonna use 8C, when we're looking at this photo, there's a blue door here.
Yes,
Is that locked?
it is locked, yes.
And where does the area by where they're doing booking over here?
They're behind the counter, there's a small room with lockers for their personal property that lock. So each cell has its own corresponding locker for the individuals who are in jail. Past that goes back into the jail.
Okay, and there's this black line in the middle of the room, and at the end of this black line, we see you walk off the screen here. Where do you go?
Coming back this way towards the camera, it goes into, which would be, we call it the turnkey room, and we have video equipment set up there. So if they're going to be arraigned through Willoughby Muni Court, all that equipment is in there for the arraignment, and then the next door is a hallway that leads you back out into the police department.
So were you pretty confident that he was gonna sit and stay there at that point?
He can't go anywhere. Everything is locked.
And was there any point in time where the defendant actually acknowledged the dollar bill or said anything about it or did anything?
Just on the video where he kind of threw his hands up.
And what type of facility is the area that's on the booking? It's not a restaurant,
No, it's a jail.
jail, and is that a detention facility where people have to stay?
Correct.
Do you actually have jail cells there?
We do.
And is that kind of overseen by the Department of Rehabilitation and Correction?
The state comes in, we have to abide by the state code. We have a supervisor that's in charge of all of that.
And are there written rules that you know of that don't allow for drugs to come into your detention facility?
Yeah, they're in the ORC.
So after this booking area, where does the defendant go?
Once we're done booking him in and getting the process done, he goes back into his cell.
And now you made a comment about him sitting there for a couple hours until he sobered up.
Correct.
How long did he stay there?
He was there for the weekend due to the conveyance of bringing in illegal substance. So he wasn't going anywhere until he was arraigned on Monday.
Now that next day on September 17th, do you recall that day?
I do.
Were you working on that day as well?
I was 6 a.m. to 6 p.m. again.
And during that period of time, did you interact with Mr. Broadwater again?
I did. I don't remember which officer went back, but they said Mr. Broadwater was requesting to speak with me.
And you knew that he wanted to smoke a cigarette?
Yes,
You made that pretty clear the day before?
numerous times.
So at this point in time, did you allow him to come out and have a cigarette?
I did. He had sobered up. He was not combative. He was polite and cordial. I had a conversation with him in the cell before I let him out. He asked if he could come out and smoke a cigarette, so I allowed him to do that.
Even though it was bad for him?
It is. Smoking will stunt your growth, yes.
All right, so when you allow him to have a cigarette, where do you go specifically?
If we let somebody smoke a cigarette, we will have dispatch crack the Sallyport door, the overhead door, the garage door, and then they can stand or sit in the Sallyport and smoke their cigarette.
So dispatch has control over that kind of, I guess, for lack of a better word, like garage door?
Correct. There's no controls in booking or in the Sallyport at all for that garage door.
And approximately how much of an opening does dispatch do?
It's normally like, I don't know, a foot to 15 inches, something like that.
And so did Mr. Broadwater go out there and did he smoke a cigarette?
Yes, he did.
So tell me what happened when he was doing that.
Mr. Broadwater went out. I lit the cigarette for him. He sat down, smoked his cigarette. There wasn't much of a conversation. He was just kind of quiet. He sat close to the edge of the garage door. When he was done, I told him to put it out. He stood up, walked around, and just kind of, I mean, there's a vacuum in there. There's cleaning products. I think there's a broom and a squeegee if we have to wipe out a car or something like that. And then there's a trash can in the other corner. So he walked up past the gun lockers, threw the butt out. I backed into the door going back into the jail so I could still keep my eye on him. And Mr. Broadwater jumped down on the floor and tried to squirt out underneath the garage door.
Well, if we're looking again, we'll just, for lack of a better one, we'll use 8C. So which, is this blue doorway, where does that go?
That goes back out into the Sallyport.
Is this what you went through to be able to go out into the Sallyport?
Correct.
And was that left open?
I did leave it open, yes.
So when you say you backed
I stepped just back over the threshold. I mean, just into it so I could still see Mr. Broadwater.
You didn't turn your back?
No, I just stepped backwards through the door.
Did he say anything to you at all?
Nothing.
And who's responsible for individuals if they're in the jail, even if they go to the Sally Port?
Well, if I'm standing there with him, I'm responsible, but it'd ultimately end up on the supervisor.
And so when he said he tried to scoot out, explain exactly what he did.
He laid down and tried to crawl underneath the door. I was able to get to him before he got most of his right arm out and part of his knee and thigh, shin area. I was able to get on top of him, get my right knee down between him and the door, and then I was able to slide my left arm up underneath his right arm that was out the door, and I pulled it back around to try and pull him back out from underneath the door.
And why is it that you used that type of force to get him to come back in?
I didn't want him escaping on my watch.
And in terms of what kind of training you had and what type of force you're supposed to use in a situation, can you tell us a little bit about that, please?
As far as use of force training?
Yes.
I mean, we have to go over the policy every year, and then hand to hand, we went through that in the academy, and then every now and then when we can afford the time, we'll have training as far as hand-to-hand control, subject control.
Now, did anyone else come to assist you during this period of time?
I did. Once I got a hold of Mr. Broadwater, I wasn't going to let him go. So I just called Officer Himes to come in on my portable radio to come in and assist me in pulling him out and getting him back to his cell.
Is it unusual for you to make a call like that?
Yeah, I don't call for help too often.
And did Officer Himes come in and help you?
He did, him and the supervisor, because when I called for help, him and the supervisor were together discussing something else, and they both came in.
Okay, who is the supervisor?
It was Sergeant Weber.
And do you know if this incident, trying to scoot up the bottom of the Sally Port, was that captured and recorded in any way?
Yes, the Sally Port is recorded. There is video and audio of it.
Your Honor, for the record, I'm showing opposing counsel states Exhibit 9. May I approach?
Yep.
I'm showing you have one for identification states Exhibit 9. Ask if you look at that and if you recognize what that is.
Yes, that's the DVD of the recording of the Sally Port, has my initials on it.
And did you watch that?
I did.
And does that fairly and accurately see the actual video from the jail?
It does.
Your Honor, at this point in time, I would move to admit and publish this to the jury.
Any objection?
No, Your Honor.
All right, submitted.
One second. Oh. What is it again? Okay.
we'll make friends.
Alright, now I'm reviewing that, that fairly accurately depicts what happened.
Yes.
At one point in time, I hear you saying stop, stop, stop. Who are you talking to?
Mr. Broadwater, he's still trying to get out.
So from the vantage point that we have, with you being in front of the defendant, it's a little harder to see him. So explain to us what's happening with him.
He was still trying to pull to get his right shoulder out. I mean, I had my arm underneath it, so his right shoulder was over top of my right arm, but he was still trying to pull to try and squirm out around my right thigh and back out.
And then looking at his size and looking at the Sally Port door, did you think that he would be able to get out?
I wasn't going to take any chances, but yes, it was. He probably could have squirted out from underneath there.
Now, you hear at one point in time him saying that he couldn't breathe. So can you explain to me what type of hold you had him in to make sure that there wasn't an issue?
I had his right shoulder, and then I came across just to kind of guide his head back out, but I didn't have him a chokehold or anything. But I mean, he was speaking quite clearly. If you can't breathe, you're out of oxygen, meaning you wouldn't be able to talk.
And here, were you using the least amount of force you could?
Yes, I didn't punch him, I didn't strike him, I was just holding on to him just to gain control.
And when you're laying kind of down, you can see you're talking on your radio. What is on your belt at that point in time when you're inside the Sally Port area booking room?
My firearm was locked up, but my taser was still on my left side, so I rolled so my left hip was up, so he couldn't reach back and get to my taser.
And why then was it 3 officers then that had to get him back in?
Sergeant Weber came in along with Officer Himes. But I mean, Officer Himes and I could have done it, but Sergeant Weber, since he is the supervisor, came back.
And for the record, I'm showing opposing counsel what I've marked as State's Exhibit 10A through 10H. May I approach?
Yep.
I'm going to show you what's been marked by identification as State's Exhibit 10A through 10H. I'm just going to ask you to look through this and let me know when you're finished.
Okay.
Okay. Can you tell me well, first of all, do you recognize what those are?
Those are all the pictures from the video. They're just stills from the video of the Sally Port.
Okay, and do they fairly and accurately depict screenshots from that particular video that we looked at, State's Exhibit 9?
Yes.
I want to go through with you first. State's Exhibit 10A. What should we observe in that particular photo?
As Mr. Broadwater sitting on the floor of the Sally Port, actually it looks like he's starting to get up from finishing his cigarette.
What can you see then? You're talking about what's in the Sally Port there. What is it that you see in that photo along the wall?
There's a ladder, a gas can, a mop bucket, a shelving unit with cleaning supplies, a vacuum. Looks like there's a squeegee or a broom in the same corner right behind him.
Do those items pose any risk to you with the defendant being in that area?
They would if he decided to grab a hold of something.
And 10B?
That's Mr. Broadwater looking at the shelving unit as he got up to start walking back.
Okay, what about 10? I'm looking at 10D first.
10D is Mr. Broadwater. He's in front of the gun lockers. He's wiping his cigarette on the wall to finish putting it out before he throws it away.
Okay, 10C?
10C is Mr. Broadwater. Looks like he's looking at me, actually.
Okay, and then 10E,
That's Mr. Broadwater pulling up his shorts, getting ready to take off.
10F,
That's Mr. Broadwater. He's got his right leg out the door, out underneath the door, and his, probably up to his elbow, out underneath the Sally Port door as I'm coming back in.
10G,
10G is Mr. Broadwater still attempting to escape the jail, and me coming back in to apprehend him again.
then on 10H, can you see your duty belt in that?
Yes.
And that's, or do you have your firearm on your belt there?
No, just a holster.
Okay, and what about your taser?
Taser is there.
And it does all fairly and accurately depict that date?
Yes.
Thanks, so much, Your Honor.
Yep.
The next day, when we have the Sally Port where he's smoking, what was the defendant's demeanor that day compared to the night before?
He was sober.
Nothing further, thank you, Your Honor.
Thank you. Cross-examination.
Thank you, Your Honor. Good afternoon, officer. I'd like to, you've looked at these on direct, showing it's been marked previously as State's Exhibit 4A. Do you recall seeing that?
I do.
And just for scale, how would you say that this is larger than the real, than an actual syringe, smaller or the same?
Well, the picture is larger.
Right.
Is that what you're asking? Is the
Yeah.
picture larger?
Yeah.
Yeah, it looks like they zoomed in.
Okay. And
I wasn't there when they.
How big are those syringes?
I don't know. Are you looking for a measurement?
Well, you're just showing with your finger.
I don't know. They're probably a little longer than a pen.
A little bit longer?
I would have to say so. I don't know. I don't know the exact measurement.
And the syringe itself, there's nothing illegal about that. You can buy that at a pharmacy, right?
Correct.
Call your attention to September 16th of 2022. Approximately what time did you arrive at the scene?
Probably 2 minutes after dispatched it. I don't have the time in front of me.
How long were you at the scene? Before you left, Mr. Brown?
Total altogether, maybe 15 minutes.
Okay. When you saw the syringe, my understanding is you put him in handcuffs,
Correct.
put him in the back of your patrol car.
Correct.
The rest of that time, you were getting witness statements, if I recall correctly?
And we looked for any additional illegal needles, anything like that, just because it is a public area. We didn't want any children or anybody else stepping on it.
You engaged in that as well, I thought it was the other ones.
All three of us were there.
So after that 15 minutes, and Mr. Broadwater was in the back of your vehicle,
Correct.
how long of a drive is it from that location to Eastlake Police Department?
Probably just a little over a quarter mile, under a half. I think the Mrs. Forgive me, I forgot her name. The manager was pretty close with a half mile, yes.
And how long did that take?
How long does it take to drive a half a mile? I don't know, maybe a minute.
And were you able to see Mr. Broadwater in your rearview mirror as you drive?
Yes.
From the time that you reached the booking area to the time you did the pat down, how much time elapsed?
I don't know. I'd have to look at the time. Maybe 5-10 minutes. I mean, it was on the film. I don't know. I didn't count it off.
Okay. You're saying the total time that Mr. Broadwater was in booking was 10 minutes?
Not the total before I found the heroin. Is that what you're asking?
No, I'm saying from the time that he was first put in that seat until the time that you did the pat down, how much time elapsed?
Well, I said we were there probably 15 minutes, and then a minute to drive it, and then maybe 10 minutes, so give or take 25, 30 minutes.
And are you familiar with the term furtive gestures?
Somewhat, yes.
Do you ever use that in your reports, in your police reports?
No.
Never?
Not that I can recall, no.
Did you ever make a note of Mr. Broadwater reaching for his waistband? Did you ever notice any of that activity?
I'd have to look at my report. I don't think I put it in there.
Okay. I'm asking if you recall firsthand.
I don't know. I'd have to look at my report, because if it happened, I would have put it in my report.
Okay. And you watched the video, you watched the booking clip today, right?
Correct.
And did you notice Mr. Broadwater make any movements toward his waistband?
No.
And you indicated, going back to the initial arrest, I apologize for sleeping.
No, you're fine.
You indicated that Mr. Broadwater's speech seemed okay, but his balance was off.
Correct.
And did you have to help him get to the squad car?
I help everybody in my police car, but I did catch him. I said in the statement, and I put it in my report, that he took a step and kind of stumbled. But
Okay.
if you're under arrest, I do escort everybody.
Okay, but he was unsteady on his feet.
Correct.
And my sense is that he was much more steady on his feet the following day on September 17th.
He was sober.
Right.
Yes.
Did you notice a difference?
Yes.
In his balance? And did you notice a difference in his speech?
His speech, his demeanor, I mean, he was pleasant.
And on the 16th, it's fair to say he was out of it. He wasn't aware.
No, he was aware. We had a conversation. We had numerous conversations.
On the 16th.
Yes. I mean, he answered all the booking questions. He answered, I mean, besides being high.
And that's what I'm saying. So you
Yeah.
could tell he was high.
Yeah.
If I could just have 1 minute.
I'm sorry, before I do that.
You indicated on direct that the decision to call for medical attention would be something you asked your supervisor if you thought that was necessary.
Correct.
Your evaluation was that that wasn't necessary.
No, I mean, he was answering all the questions for the booking, everything else. He didn't request any medical, You know, people normally, when they come in, if they have an issue, they'll be the first ones hollering and screaming that they want a squad because they're gonna try and work the system and get out of jail.
But you, at that point, you interviewed, both the store manager and the assistant store manager at, Dollar General,
At what point?
by the time that you had reached booking.
Yeah, we had already, yes,
Right. And they indicated that he was kissing the wall and in a fetal position, and,
yes.
but even knowing that information, your perception was there was no need for medical.
At that point, no, he didn't request anything, and we didn't see a need for it as of yet.
Pardon me, Your Honor. Thank you, Your Honor.
Any redirect?
Yes, Your Honor, thank you.
Officer, in the photograph of the syringe, that's just to photograph it. It's not, we're not talking about a syringe that's like a foot long.
Correct.
It's, is it a normal, regular size syringe that we would see, you said, for somebody who's diabetic?
Correct. Yeah, like it, you can purchase it over the counter, but this one was full of illegal substance.
And you could see it, is there like a specific color that you can see on that syringe? Like the cap, is it usually a certain color?
I think they're orange, I think.
And when you observed this, did it appear to be like your regular, everyday, came from the package or used for diabetics syringe on the ground?
Yes.
What was different about it that made you feel that you need to place the defendant under arrest?
It was between his legs, and it had a little bit of blood on it, and inside it had a little bit of brown residue, right where the plunger comes down to the bottom of the syringe.
And your training experience, what does that tell you?
It's got some sort of illegal substance in it.
And did that coincide with the type of behavior that you were seeing or demeanor that you were seeing from the defendant?
Yes.
When the defendant was handcuffed, where was he handcuffed? Front or back, side?
Back.
In the back?
Mm-hmm.
In the back? And when you did that, is that how it was when you placed him in the patrol car?
Yes.
And was he able to free his hands or do anything at that point in time?
No.
And when you are back in booking, where are the other officers in relation to where the defendant is in booking?
When we first get back, they were on their way back. I think they finished obtaining the statements from the store managers, and then they came back into the booking room to assist.
And then you and Officer Wright and Officer Hodgkiss, were you in there with the defendant?
Yes, all three of us were.
And in terms of medical attention, you didn't get the impression that he was bleeding from anywhere?
No.
That would have been in your report?
Yes.
That he was overdosing?
No.
Have you seen an individual who's overdosed before?
Yes, they're normally incapacitated.
And that was not the case here?
Correct.
You said other than being high, did you see any other need for medical attention?
None.
Any recross?
Thank you, Your Honor. You said Mr. Brownwater was cuffed in the back.
Correct.
Okay. Would you agree that the shorts that he was wearing at the time of his arrest were baggy?
Yeah, they're like gym shorts, basketball shorts.
Right. And they appeared to be loose fitting. Is that what your perception was at the scene?
Correct.
So you say he couldn't do anything. He could have pulled them to the side.
What do you mean couldn't do anything?
You indicated on, redirect that his hands were cuffed, he was in the back of the car, he couldn't do anything.
Correct.
But he could have pulled his shorts to the side while he was in the back of the car.
Be a little tough, but if you,
Have you ever had an arrestee, trying to deposit drugs in the back of the car?
yes,
And in fact, isn't it true, one of your procedures is to check the back of the car periodically to make sure that that doesn't happen?
prior to shift and then after you arrest anybody, yes.
From the booking video, and you talked a little bit about it on direct, there's a period where he's sitting alone.
Correct.
And one of the questions was, were you
Objection.
concerned? You said,
So, sustain.
so. You indicated on redirect, that there were other officers with him in booking,
Correct.
but there, part of the time he was alone.
Correct. He was on film.
Right, but there were no other people in the room.
Correct.
Nothing really.
All right, you may step down. Thank you.
Thank you.
Next witness.
Thank you, Your Honor. State would call Officer Gary Hotchkiss to the stand.
You raise your right hand, please. You swear a testimony about to give us the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
All right, have a seat. Good.
Thank you, Your Honor. Can you please introduce yourself to the jury and spell your last name for the record?
Gary Hotchkiss, Hotchkiss.
Where are you employed?
City of Eastlake.
What's your position with the city?
Patrolman.
And how long have you been a patrolman there?
Coming up on 7 years.
Do you have any other prior law enforcement experience other than working for Eastlake?
Had a year with Notre Dame College.
Tell us a little bit about your background and your education.
Basic police academy to start, and then multiple continuing education schools and things like that.
And you're a certified police officer in the state of Ohio?
Yes, I am.
How long have you been certified?
Almost 8 years.
In the course of your training, did you have an opportunity to do any training regarding illegal narcotics or drugs, any substances like that?
Yes,
And how often have you had that and how much?
quite a bit. I don't. We see drugs a lot, and we see those types of situations a lot.
Your basic academy, did you deal with that there?
Yes,
And any other schools or trainings after that?
yes.
And then with working at the Eastlake Police Department as an officer, how many times would you say within a given week would you deal with an individual who had narcotics of some sort?
Multiple times a week. It depends.
What about syringes?
We see syringes semi-frequently.
Related to drugs or unrelated?
Both.
I want to direct your attention now back to September 16th of last year. Do you recall who were working on that day?
Yes, I do.
And were you working?
Yes, I was.
What shift and hours were you working that day?
I believe we were 6 a.m. to 6 p.m.
Anybody else working with you on shift that day?
Yes.
Who was working with you on that shift?
I believe Sergeant Weber, Special Patrolman Eden, and Patrolman Himes, and then I was training Patrolman Reich.
That's Jacob, right?
Yes.
And on that day, did you have an opportunity to respond to Dollar General?
Yes, I did.
And why was that?
Initial call was for a male making out with the wall, I believe.
Unusual kind of call?
I'm sorry?
Unusual call?
Yes, it was.
And did you respond?
Yes, I did.
Any other officers respond to the scene?
Yes, Special Eden did, and then Patrolman Reich did with me because I was training him.
And who arrived first?
Special Eden.
When you arrived, what, if anything, did you observe?
When I arrived on scene, Patrolman Eden, just based on the way he was acting, he waited for me to get there. And
Wait, who was acting?
Matthew Broadwater.
Wait, so the way that Matthew Broadwater was acting, he waited for you to arrive?
Correct.
How long after he arrived did you arrive, if you know?
I don't have the answer to that. And then when I arrived, he was standing against the wall, mouthing at it, almost like he was trying to kiss or make out with the wall. He was unsteady. He was sweating. Didn't know we were there. He was
How
unaware
did you know that?
because we had called out to him and he didn't even turn around.
I'm gonna show you first what's been marked for identification, which is a safe exhibit, 1D. Can I approach your honor?
Yeah.
Showing this marked for identification in safe exhibit 1D and ask if you recognize that area,
Yes, I do.
and what do you recognize about it?
From where the picture is taken, that's Dollar General, which I believe is where the caller was from, and where the X is marked on it is our laundromat, and, well, the building, that corner unit is the laundromat, and then where the X is where we found Matthew Broadwater.
I'm gonna show you with marked as safe exhibit 2A and 2B, ask if you recognize those photos,
Yes, I do.
and how do you recognize them?
That was Matthew Broadwater in the position he was in when we arrived.
And you recall seeing him specifically?
Yes, I do.
And how long did you have an opportunity to observe him?
A short time. Once I got on scene, Special Eden and I approached, and then we began dealing with him at that point. So, a matter of 30 seconds, maybe a minute.
Okay. And in responding and going up to him, did you notice anything on him or around him that was of note?
Nothing on him initially. We did locate a syringe next to his cell phone at his feet.
Was there anything significant about that syringe?
Nothing out of the ordinary, but it was a syringe. We suspected that it was loaded. We immediately took custody of it and handed it to Patrolman Wright to put it in an evidence bag just to stow it in the car for safekeeping.
Okay. And was it your understanding that there was some sort of potential residue in there?
Yes.
And when you see syringes like that, I should say, how often do you see syringes like that?
Again, we see them multiple times a week sometimes.
And in your training and experience, how are syringes like that related to drug use?
Normally, it's one of the main ways that people administer drugs.
So based on the fact that there was a syringe there and the defendant's behavior, what, if any, conclusion did you draw as a result of that?
It appeared that he was under the influence of something or was using drugs based on how he was acting and based on the evidence that we found.
Penny hand you has been marked for identification as State Exhibit 4A. Ask if you recognize that.
Yes, I do.
What is that?
That's the syringe we located.
The question was asked before, but just to be clear, that is not to scale. That the way that
As
was.
large as it looks in the picture. No, it is not.
All right, so if you can tell us how big was the syringe that was at stake?
It's approximately 4 inches.
And when you're looking at it, is there any kind of color to it at all that would bring that to your attention when it was on the ground?
What? I'm sorry, I don't understand what you're
What color is the cap?
asking. Orange.
And the bottom portion of it,
Both orange.
so were you able to see that right away upon coming on the scene? you got back to the station, did you have any additional interaction with Mr. Broadwater?
Yes, we did.
What was your specific interaction with him back in the booking room?
My specific interaction with him was indirect. Patrolman Reich and I were working on the booking process. Again, I was in training with him. So we were working on some of the paperwork end and the actual booking him into the computer. While we were doing that, Patrolman Eden stepped up and did an additional search, which is what we always do when we bring him into the jail. While he was searching him, he located a dollar bill. Dollar bill had, I think it was brown residue in it or powder or something like that. He handed the dollar bill to me. When he did, I ended up checking it like we always do. We open it slowly. I located the powder. We immediately put that into a glove just to keep it sealed, and then we continued with the booking process.
Were you wearing gloves at the time?
Yes, I was.
And so you said you took the glove, so you take the item up and then you pull the glove off so that it's inside the glove?
Correct.
I'm gonna show you with the marker identifications, State Exhibit 4D, 4E, and 4G. Actually, take a look at those and tell me if you recognize those.
Yes, I do.
Okay, and how is it that you recognize those?
The one picture, or two of the pictures, has the folded dollar bill that Special Eden gave to me. They also have the glove that we secured the evidence in, and then two of the pictures have whatever the brown substance was that we located in there.
And then once you got the substance and the dollar bill from Special Eden, what did you do with it then? After you put it in the glove?
We put it in the glove, then we completed what we needed in the booking room, then Patrolman Reich and I went back and it was logged into evidence.
And for the record, I'm showing opposing counsel State's Exhibit 6A and 6B. May I approach? Okay. Just take a look at 6A and 6B and tell me if you recognize anything about that.
That's the evidence envelope that we secured that evidence in.
And how do you know that that's the same envelope?
It has the report number at the top. It has a description of the evidence. It has the suspect. It has date and time of recovery, location where it was recovered.
So those fairly accurately depict what you did in terms of the evidence with Officer Wright, who was in training on that day?
Yes.
And were these items, the syringe and the glove with the dollar bill and the brown substance, were they all secured in evidence?
Yes, they were.
And once they were secured in evidence, where did they go from there?
They normally go to the Lake County Crime Lab.
You know that what happened here?
I believe so.
Once those items go to the Lake County Crime Lab for testing, you receive a lab report afterwards?
I did not receive a lab report, but we do receive a lab report.
This individual that you were talking about that you saw against the wall that had a syringe in his feet and had this dollar bill with the brown substance, do you see that individual here in the photo today?
Yes, I do.
Would you please point out now, describe what they're wearing?
He's wearing a gray suit, gray or light colored shirt. He's sitting all the way to my left.
May the record reflect the identification, Your Honor?
Yes.
Let me just have a moment. Nothing further, thank you.
Ross?
Thank you, Your Honor. Good afternoon, officer.
Hello, sir.
Calling your attention to September 16th. My understanding is you were the second person at the scene.
That's correct.
Officer Eaton was there first, or Sergeant Eaton?
Yes, he was.
And were you driving the patrol car that you arrived at the scene in, or was the officer you were training driving?
I don't recall.
As you exited your vehicle, how far away were you from Mr. Broadway?
We were probably 50 feet.
And how close was Sergeant Eaton?
He was probably more like 30 feet because he was closer by his vehicle.
Okay. And did you arrive at Mr. Broadwater at approximately the same time?
Not at the same time.
How much of a difference was it?
I would have to look at what time we called out.
Well, just based on your memory.
Maybe 30 seconds to a minute.
And if I understood you correctly on direct, you were saying that Mr. Broadwater was not responsive to your initial remarks. Is that accurate?
Correct. Initially, he was not.
And is it fair to say he appeared to be impaired?
Yes.
Was he standing upright the entire time you were interacting with him at the scene?
Yes.
What were you doing as Mr. Broadwater was being in?
I was standing there in support of Special Eden.
Okay, you were right there.
Correct.
During any of your interactions with Mr. Broadwater on the 16th, did you ever see him make any movements toward the waistband of his shorts or toward his shorts at all?
No, I did not.
And you said as you approached, he was unsteady and sweating. Is that correct?
Yes.
How long were you how long were you in booking with Mr. Broadwater?
Again, I'd have to look at the time.
Well, just based on your memory.
Usually a booking process takes us approximately 40, 45 minutes. We would have been in for most of that time.
Okay. And do you recall observing Mr. Broadwater reach for his waistband or reach for his shorts in any way?
No, I do not remember him doing that.
And he was falling asleep. Is that fair to say?
Yes, he was.
And it was an effort to keep him up to get through the booking process. Is that accurate?
Yes.
And you had to rouse him a number of times, correct?
Yes.
Do you recall receiving something from Sergeant Eaton after he patted down Mr. Broadwater?
Yes, I do.
Could you describe what happened to that item? What you did with it when you received it, and what you did with it?
So I was standing behind the booking counter. As I said, we were working on the paperwork and the computer process for booking. Special Eden was conducting the search. When he pulled out that dollar bill, he immediately looked at me and said, "Here you go." When I saw the dollar bill, normally we find drugs wrapped in a dollar bill that was folded like that, so I immediately changed out my gloves from my cloth normal gloves to the actual black nitrile gloves. Put those on, and then I took that evidence. I immediately checked, or opened it up and unfolded it slowly, located the brown powder on the inside, took that and immediately secured that in the black gloves so that it wouldn't go anywhere. And then I placed that on the right side of the booking counter away from the front.
Okay. So you in terms of time, you change out your gloves, put black gloves on, check the substance, you saw something was there,
Yes.
and then you put it in a glove and it on.
put it in the glove.
It happened that quickly.
We put it in a glove, we completed our process, then it was placed into the evidence envelope when we left booking.
Were you responsible for sending this sample to the crime lab?
We completed the paperwork for it. We did not personally take it to the lab.
Okay, do you know who did?
No, I would have to check the follow-up supplements.
Back to everyone. Nothing further, thank you.
You redirect?
Thank you, Your Honor.
I'm gonna mark this for identification, okay, called State's Exhibit 11. Look at State's Exhibit 11, and tell me, in relation to the dollar bill that was handed to you, and the way it was folded, how does that compare to what we're seeing there?
It's folded in a similar fashion.
And so, in looking at that, when you were able to take a look at it, how did you open that?
Normally, if we found a piece of paper like this, try to keep the open ends of the fold upright so that whatever's in it doesn't leak anywhere. Then basically we would unfold it one step at a time. So I would unfold the first fold and get a crease that I make sure is basically cupped. If there's nothing in that crease, then I would readjust what is folded. I would make sure that when I open the next crease that it's cupped underneath, so if anything's in it, it doesn't fall out.
So that would be a similar type of fold to what you observed?
Yes.
And for the record, I'm showing opposing counsel to mark as State's Exhibit 5. Any questions? Have you take a look at State's Exhibit 5 and tell me if you're familiar with what that is.
This is our Lake County Crime Lab sheet when we have to submit evidence to the county. And this one specifically is for this case.
And who was it then who would have submitted that to Crime Lab, if you can tell from looking at that?
I believe the signature is Tim Hauser.
And what is Tim Hauser's role at the Lake Police Department?
He deals with our evidence room.
And so, after placing these items in evidence, according to the evidence submission form, Officer Hauser would have taken it to the lab.
Objection. Overruled.
Okay, when Mr. Patika asked you about if there were any movements that were being made towards his waistband, what about towards the defendant's phone? When you see any there, do you try to make any movements to get his phone?
No, he wasn't making any movements to get anything. And at a later date, he asked about his phone because he didn't remember where it was or anything.
And did, based on your observations, did the defendant appear to need medical attention?
No.
Objection.
Sustained.
In looking at the defendant's behavior, is it unusual to see behavior like that in someone who is under the influence?
It is not unusual to see that behavior.
Any recross?
No, thank you, Your Honor.
All right, you may step down.
Thanks, sir.
All right, we're going to take about a 10-minute break. Remember not to discuss the case. Don't try to find out any information from any other source. And do not come to any conclusion until the case is submitted to you. So we'll see you in about 10 minutes or so. Okay, how long do you think Patrolman Hines will be?
He'll be short.
Okay, so is Gilson here also?
I had originally told her 3, but I'm gonna ask if she could just head here now.
Okay.
I have Bills and Tyler's, but I don't have Ken's.
Okay. I'll get her.
There's nothing unusual about
Can you please head this way?
taking the Dollar General where they handled that, and it's on the video. So the more we ask, the more we're gonna have a chance to respond.
Anything missing?
No, he's saying, he's saying he got it. Yeah, they have to change gloves. You know, he got the black gloves that they wear. Yeah, but what he said, I changed the gloves. I opened here, and he saw there was something brown in there. He wrapped in the glove and sent it. But there's nothing in there that's helpful to him. I mean, it's why would they rely about that? What? Yeah, but I don't see how that helps.
He had him on the whole time. I like your promotion too. I thought she, sergeant, she did work on it.
Yeah, no, I agree.
With back pay.
Yeah, exactly.
Thanks, sir. Pardon? You know that? Pardon? But they never said anything. Why don't you explain why you took each other this out? You don't have to camera where you interrogated me to write that statement. Because I asked them not to. Because I don't want to put on the record that you were trying to snitch. Yeah, but then none of that's coming out. And I didn't want it to come in. Because it wasn't helpful to you. Yeah, but I'm just saying that's how it happened. And here's the agreement was, they were gonna bring it up. And then unless I open the door, and then if I open the door, then they were, that's, we don't wanna make a record of it. Yeah, okay, I just wanted to understand, yeah. No, here's the other one, this is not related to your case. We see charges like this all the time. So I've told you all along, I don't necessarily think it's fair, but they might be on the all of us. But I've had plenty of clients that are trying to put the stuff in the car. That was the only way I thought to approach it. And when you're sitting there, you're not down to your waistband, you're not, but voluntary intoxication, someone trying to, kind of hint at it, but we can't say. But that's, you're doing a good job of relaying the questions to me for the issues. If I don't ask an issue, it's not that I'm ignoring you, but there's a reason. I think there's more downside. Here's one more cop, and then the lady from the left. It might be today, it might be tomorrow morning. I don't think it'll go past it. We're wrapping up today at 4. So it's 3 after 2 now. Well, the judge showed us this morning, we're done at 4.
Is there 14? It was the last guy there.
2.
Okay. Because yeah, I just saw the last, all my last one.
John?
You're doing good with that, just keep up to it.
Doing any good over the weekend?
Well, I went with the Red Wine and Brew Friday. Cigar Shield.
Oh, Cigars and Shield.
Gonzo's there, and he just had to be up there.
I heard it was kind of busy. We went to that, I bought a school bus.
Yeah, John was, or Thompson was saying that,
Yeah.
because John, they're gonna use it to go to the, phone car bomb, and he said,
Yeah.
yeah. So they're talking about it.
So I took a bunch of people down to Medina. They had like midget wrestling.
Oh, yeah, okay.
So they're like, so we don't have to worry about drinking and driving. I'm like,
Yeah.
We'll take the bus, I don't care.
Yeah, that's pretty.
Where are we going? When?
I think May 17th, it's a Wednesday. John's having our meeting there at his own car lounge. Jordan's some kind of, you know, like a steak bourbon or dinner bourbon thing.
Oh, okay.
You know, for, I think.
Police Week.
Police Week.
Yeah.
John's
that's
been turning
Wednesday.
in- Yeah.
Yeah,
May
that's because
17th.
Friday I leave. I'm going to DC for the Candlelight Vigil
Oh,
for
okay.
Police Week.
Yeah, yeah. John's turning that into our meeting too, and Thompson said that, you know, you have a school bus, 'cause John was gonna get a limo bus or whatever. I don't know.
School bus won't pop in.
That's what I'm saying, and yeah, that's what Thompson said. So. Yeah, that's what Thompson said.
Yeah, I registered as an RV.
That's cool. I mean, basically. You're still in the club? You're not in the club anymore. Oh, are you? Oh, I couldn't remember.
I got skin cancer real bad, so in the winter, I'm not going around sitting those places.
Oh, yeah, I don't like going away. You know, it's like walking into a house fire.
Oh my Jesus. Yeah.
But that's what I'm talking about. I don't do that. You see me go back a couple times. It's housekeeping stuff.
Okay, she's on her way. Okay. We dealt with those.
Was that the crime lab you called?
Yes. Never come out.
They have crime lab in the trial last week, this week today. Trial takes a long time. Just 2 weeks.
It all depends.
So we had a
There's nothing more.
yeah, officers and stuff, this is credentials, but cell track.
Any big plans for the weekend?
I had a,
No, so.
I think. That's why I'm in trial.
Yeah.
We'll see if I'm in
I
trial.
had scary what they
I am
did.
bachelor
Oh, I
all
know.
weekend.
I had that in a case last year.
I've had 2 so far.
Supposed to be nice.
But I need to get cell phone records on like that.
Well,
I'm more of
that's
a bourbon
gonna
guy.
be-
Oh, bourbon.
Yeah, scotch is.
There's a lot of bourbon.
Well,
guys.
Scotch for- it's for the,
Better that I have that stuff for jury trial
Diesel
right now.
Oh, yeah.
Gonzo.
People who think that they're
That
really
stuff from.
Bob.
No, Gonzo's a bourbon guy.
Scotch versus bourbon.
Bourbon.
See?
Well, when it's,
The only person that would, I mean, the only person I know is the Diesel, or Judge
Well,
Diesel.
that's Mr. Fancy
Yeah,
Pants.
I know.
yeah, but
Diesel.
They're all-
it doesn't tell you the big
Good
difference.
two-shoe people.
Correct.
But on the other hand, it puts them, they don't get around it.
Bob would get it.
I shouldn't say no get around, because that stuff isn't infallible.
For my trial.
Yeah, it's gonna be a mess.
coming
You're
up
gonna have to
with
go
it,
back for him all
It
day
doesn't put her near it.
Sorry, Bob.
He's got crumbs all over the floor.
I know what that's like.
Dog's cookies.
My
Dog
nephew,
biscuits.
It was a crazy case, but there were like 3 separate
Double dog
allegations.
itself.
Yeah.
And I'm going like he was
Yeah.
left up on Willoughby and he was,
Okay.
and there were 3 separate vandalism incidents. And it's known as progressive.
Yeah.
I know, I was thinking about banging off this weekend, maybe go for a
Nowhere near
raw.
better.
It's gonna be a lady going, I don't even know why work.
When I showed Lisa at the initially, she was like, that was fucking nice.
Call in, tell me I have something in my eye.
Well,
Can't see
we'll see what the
myself
truth
at work.
That's a really good one.
Once,
I like that.
well, no, but,
Time's still
well,
up
what,
there. He's like,
No,
like with,
he's in there.
with my dealings with Lisa, it snows up or thumbs down, is it?
He's another
End of
fellow
discussion.
oh, really?
Were you guys at Lejeune?
Oh, not together, but.
Well, yeah.
That was my
Wait, about the
last.
same age?
Yeah,
Whatever.
but that always, it's like, at least.
No, I used to live in Jacksonville.
Oh, really?
Yeah.
That shithole.
Yeah.
Like that same case, I'm like, there's
Pawn shop,
other things that
tattoo joint.
she was like, oh yeah, I'll give it to them and investigate. They
Yeah.
didn't do anything. They didn't do anything else.
Yeah, when I lived there, I was trying to find somewhere to work because it was before I went to law school. It was like restaurant. That was the only place. So it was bar, strip club, tattoo shop,
Yeah.
or divorce attorneys. There's a lot of divorce attorneys.
Wow.
That's all I heard was strip clubs and divorce.
They just don't understand. I got married when I was in the Marine Corps. Way too young.
So did my dad.
Yeah.
I mean, that's why I was down there because my ex was in the military. I got married when I was 20. So.
Yeah. I called home. I'm like, hey, Dad, I got married and I got a dog. What kind of dog did you get? Like, Thanksgiving would be sweet. I'll see you then.
Nice.
Mm-hmm. Well, you know why divorce is so expensive? It's worth it.
Okay.
Right.
Thank you. See if you can. Can, it's no big deal. Use that. Gotta put it on the
Seated, please. Witness.
Thank you, Your Honor. The state would call Officer Max Himes to the stand.
You raise your right hand, please. You swear testimony about give us the truth, the whole truth, and nothing but the truth, so help you God. Right, have a seat.
You could please introduce yourself to the jury, spell your first and your last name for the record as well.
Patrolman Max Himes, M-A-X, last name H-I-M-E-S.
Can you tell us a little bit about where you're employed and what you do here?
Eastlake Police Department, I'm a patrolman for the city,
And how long have you been a patrolman for Eastlake?
almost 4 years.
Any other prior law enforcement experience?
No.
Tell us a little bit about your training and education, your background that qualified you to be a police officer.
I went through the basic police academy. I've gone to several other trainings that have helped me become more proficient at my job.
Any training regarding drugs, drug use?
Yes, I went to A-RIDE, which is an advanced detection asset for cops on the road so we can see who's under the influence of various things.
And when was that training, do you recall?
2022, I believe.
In this particular case, I want to direct you back, it would be the 17th of September of last year. Do you recall if you were working on that day?
I do.
And were you, what shift and hours would you have been working?
I'd have been working day shift 6 a.m. to 6 p.m.
Anybody else working on the same shift with you?
Yeah, Patrolman Eden, and I believe Patrolman Hotchkiss, he might have been there.
During the course of your work on that day, did something unusual happen regarding the Sally Port area of this jail?
Yes.
Can you explain to the jury what was you observed?
On the radio, I heard Patrolman Eden call for me to respond to the jail, which he often does not do. So me and Sergeant Weber responded back there. Came into the jail, didn't see anything. Garage door was open to the Sally Port. Looked in, saw Patrolman Eden on top of Matthew Broadwater.
And when you observed that, well, when you initially got the call, was that unusual for you to get a call like that?
Yes,
How often has that happened before?
once or twice in my career.
And what does that, when you get a call like that, what does that signify to you as an officer?
Something bad's happening.
And so you did in fact respond there?
Yes.
And what, if anything, did you do?
I helped assist by handcuffing Matthew Broadwater. I grabbed his right arm from under the Sally Port, started putting handcuffs on him.
When you first got out to the Sally Port area, what was the first thing that you observed?
When I saw into the Sally Port, that Matthew was partially under the door and Patrolman Eden was on top of him.
And what was your role? What did you do when you got yourself involved?
Handcuffed and helped relieve Patrolman Eden.
Have you had an opportunity to look at the Sally Port video?
Yes.
There's a portion of that video where the defendant's arm is kind of straight up and down. Can you explain that?
So in order to handcuff him, I had to pull his arm actually under the garage. I held it between my legs while I was squatting down, just so I can put the handcuffs on him more easily instead of trying to drag him out by an arm.
And during the course of trying to get him cuffed and get him back in the building, how would you describe his demeanor?
Honestly, I can't recall at the time how he was being. I think he was fairly quiet.
Was he cooperative?
At the time I had his arm, yes.
Prior to that?
I would assume not for Patrolman Eden.
You know, for you, though, when you initially came in, was he cooperating with what Officer Eden wanted him to do?
No.
Okay, the individual that we're talking about, do you see him in the courtroom here today?
I do.
Can you please point out and describe what he's wearing?
He's wearing a gray blazer and a gray shirt.
May the record reflect the identification, Your Honor?
Yes.
Nothing further, thank you, Your Honor.
Cross-examination?
Thank you, Your Honor.
You answered the radio call with a supervisor, is that true?
That's correct.
Who got there first, you or the supervisor?
I believe we both arrived at the same time. I may have entered the room or the Sally Port first.
Okay. And what did the supervisor do?
I think he also assisted with handcuffing. I think he took control of, it would have been his left arm, I believe.
Okay. And you said on direct that you assumed that Mr. Broadwater wasn't cooperative prior to you getting there?
I would assume that.
Okay, but you don't know that for sure?
Not 100%.
Nothing further.
Any redirect?
No, Your Honor,
All right, you
thank
may
you.
step down. Thank you.
Thanks, sir.
All right, next witness.
State would call Kim Gilson from the Lake County Crime Lab.
Will you raise your right hand, please? You swear testimony you're about to give us the truth, the whole truth, and nothing but the truth, so help you God.
I do.
All right, have a seat. Go ahead.
Good afternoon.
If you could please introduce yourself to the jury and spell your last name.
My name is Kimberly Gilson, and it's Gilson.
Can you explain to the jury where you're employed and what you do there? This is the basic part.
I am employed at the Lake County Crime Laboratory, and I'm a forensic analyst, and my duties include analyzing solid dose evidence for the presence of controlled substances like marijuana, heroin, meth, cocaine, just to name a few.
And how long have you been working for the Lake County Crime Lab?
I am in my 13th year working at the lab.
So that would be 2010.
That's correct.
Can you tell us a little bit about the Lake County Crime Lab
Crime Lab is accredited, and we are accredited through an organization known as ANAB, which stands for the American National Standards Institute National Accreditation Board. And for us to be accredited, that means that the laboratory goes through a rigorous process of ensuring that our procedures and policies follow guidelines that have been put in place throughout the forensic field, both nationally and internationally. And part of that process involves the laboratory going through surveillance visits where ANAB will go through our procedures and different parts of the laboratory. And then every 4 years, we go through a reaccreditation process where members from ANAB come into the lab and they look at every single portion of the laboratory where no stone goes unturned. Every employee is looked at for their employment record and their training records. Our cases that have been reported are looked through, and then also our procedures and policies, and any new instrumentation and procedures that we have put in place since our last reaccreditation will also be reviewed to ensure that all of our reports and all of our findings are true and accurate to what our testing allows us.
Now, prior to being ANAB, was there a different set of letters that were used for the accreditation?
Yes. Prior to, I think it's been about 2 years now that we've been under ANAB, we were accredited through an organization known as ASCLD Lab. And the reason for the change is because ASCLD Lab and ANAB merged, and ANAB won out on the name.
And the accreditation process that you're talking about, is it kind of just a one and done?
No, it's not. It's a cyclical process. So we became accredited, and then, how I had mentioned, we go through a reaccreditation every 4 years.
When you talk about being accredited, what types of things are you accredited in at the crime lab? Not just you, but the lab itself.
Every section of the laboratory is accredited, and we are a full service lab, so that means every department. We have fingerprints, firearms, trace analysis, toxicology, and DNA analysis. All of those areas are accredited.
Tell us a little bit about the education you actually had that got you to this point where you are now.
So my education started at the College of Worcester, where I earned my Bachelor of Arts degree in Biochemistry and Molecular Biology. I earned that in May of 2010, and then I went on to complete an internship at the laboratory in the summer of 2010, and then was one of the lucky few that was hired on full-time in September of 2010. And part of my training at the beginning, I went through a rigorous 6-month in-house training program under my supervisor at the time, where I completed supervised casework, in-house proficiency tests, and also written competency tests for all the different aspects of my duties and my job. And once that training was complete, I was able to perform casework on my own and release reports under my name.
What about any certification you might have?
I am certified in drug analysis through the American Board of Criminalistics. And I'll also mention that I went through a week-long forensic chemist seminar through the Drug Enforcement Administration in 2011 as well as a part of my training.
Any other trainings or continuing education that you've had recently?
Part of our accreditation, every analyst has to complete at least one continuing education course per year. I follow those guidelines. If it's feasible, I will complete more than one. The most recent training that I completed, I went to an Ohio drug chemists meeting where all the different scientists from all of the laboratories around Ohio met to just discuss new drug trends that we have been seeing around the state of Ohio.
And in terms of professional organizations, are you required to be involved in professional organizations?
It's not a requirement. It's helpful to be a part of organizations just so that you can stay in close contact with other scientists, not only in Ohio, but around the country and around the world, where we can be in contact to just talk about the drug trends that are being seen and to talk about any new instrumental procedures that are being used for drug identification.
And are you a member of any of those professional organizations?
Yes, I am. I am a member of the American Board of Criminalistics, the American Chemical Society, the Clandestine Laboratory Investigating Chemists Association, the Midwestern Association of Forensic Scientists, the Ohio Identification Officers Association, and also the International Association of Identification. I probably slipped up on some of them, but that's the majority of them.
All right, and you mentioned the term solid dose, and how does that relate to controlled substances and what you do?
So with controlled substances, and when I'm talking about solid dose, I'm talking about working with the actual substance. So I'm dealing with powders, rocky material, plant material, liquids, and even we deal with paraphernalia where there are possible drug residues. Controlled substances sometimes gets mixed up with toxicology, but toxicology is dealing with body fluids, looking for potential drugs that are in the body system, while drugs, controlled substances, is looking at the actual drug substance that was on a person, found in a home, found in a car, just to name a few places.
Now, in terms of testimony, you're testifying here today, would you testify as an expert in any other courts or cases?
Yes, I have. I have testified in Lake County Common Pleas Court, Lake County Juvenile Court, and I've also testified for the United States District Court for the Northern District of Ohio.
Approximately how many times have you been found to be an expert?
I have testified 53 times, and I believe all of those times I've been found an expert.
And in terms of testing, you do the solid dose testing, what about fentanyl? How often do you see that?
Fentanyl, I am seeing fentanyl hundreds of times a year now. It began to show up in casework around 2012, 2013, and it ramped up a lot from that time. It has plateaued now, but we're still seeing fentanyl hundreds of times a year in our casework.
When I talk about fentanyl, are there other types of drugs that also have fentanyl as part of their needs?
Yes, there are.
What are some of those?
So fentanyl is the main one that you hear about in the news, and that's typically what everyone talks about when it comes to drugs. But there are other substances that are related to fentanyl. I like to refer to them as fentanyl's cousins. So they fall in the same family tree as fentanyl, and they're following that same backbone, that chemical backbone that fentanyl has. But they are a different substance where that chemical backbone has been tweaked slightly. So just to name a few that we see commonly, there's parafluorofentanyl, despropionyl fentanyl, also known as 4-AMPP. We see parafluoroacetylfentanyl from time to time, just to name a few. But there are hundreds of these cousins. It's a extended family tree of fentanyl. And in Lake County, we've seen a handful of them. We've seen probably about 20 or so of these cousins.
And do you see mixtures of those substances very often?
Yes, it's very uncommon to only see fentanyl on its own in a substance. We have seen a lot of polydrug use where there is more than one substance identified in the evidence that we are testing. We see anywhere from, I would say, 3 to I've had a case where I've identified 11 substances in one item.
Say that I am from a police department and I have some drugs that I have obtained as evidence and I want to bring them to the lab. What would be the procedure for it to eventually get to you?
So for evidence to come into the laboratory, one, it has to be submitted by a police agency. And the laboratory is a secure building where we do not just allow anybody off the street to come in and submit evidence. For the police agency to get into the building, they have to be buzzed in, so they have to be identified as who they are, and then they are only allowed into our lobby area of the laboratory. When they're submitting evidence, they're submitting the evidence, and they also will submit a laboratory submission form with the evidence that will include all of the case information, contact information for the scientists if they need to contact the investigating officers on the case, and it will also give a description of the evidence that's being submitted to the laboratory. Our evidence custodians are typically the individuals that will accept the evidence into the laboratory, and prior to them accepting that evidence into the laboratory, they ensure that the evidence is properly sealed. So this is making sure that nothing can enter or exit the packaging. And if the evidence is not properly sealed, then that evidence will not be accepted at the time until it has been made properly sealed. The evidence will be entered into our laboratory system that we have at the lab, and that case will be given a unique identifier so that the laboratory can identify what the case is. And this is a number that is different from the agency's case number or any other number that's associated with that case. And then each piece of evidence that is submitted will also be given a number, and that typically just goes in sequential order. So however many items are in a case, it'll start with one and go up from there. Once everything has been entered into our computer system, that evidence submission form that was submitted will be signed by the submitting officer and dated, and then also signed by our evidence custodian who entered the evidence into the laboratory system. And then our evidence custodian will take that evidence and place it into our locked evidence room. And that is where the evidence remains until the scientists who will be working on the case will retrieve the evidence and start their analysis.
So that when it actually comes, are there any special procedures in addition to what you said for fentanyl-related compounds?
We have had very open communication with all of the police agencies that we typically request if they suspect the evidence to be a powder or a potential fentanyl substance. We ask for them to double bag the evidence so that there's an even smaller chance of any evidence escaping the packaging. And that's really all we ask them to do, is just double bag it. And then they can also put a description on the submission form. If they potentially think it's fentanyl, they could notify us that that's what they think it possibly is.
When you talk about a submission form, when you receive a submission form at the crime lab, is that the officer saying this is what I think it is?
Sometimes. It really depends on the officer. Sometimes they'll give us what they think the substance is. Other times we are just given a brief description of, say, white powder or blue tablets.
And do you go with just what their description is, or do you do your own analysis?
We do our own analysis. We're only using the description on the submission form. Say if they're describing one item and when I open it, say they describe it as blue tablets and I open it and it's a white powder, then I'm going to look at that description and contact the agency to just verify that that is what I'm supposed to be receiving. If they're giving me a potential idea of what they think the substance is, I really don't look at that, because my analysis, I'm going to perform the variety of analysis on the substance to determine what is actually present in that substance.
And do you, when you receive items to test, do you only receive the drugs themselves, or is there any other paraphernalia that you do test?
We receive both drugs, if drugs are present, and then we also will accept paraphernalia into the laboratory, and that is anywhere from syringes, packaging that potentially held a substance at one time. We get smoking pipes. That's just to name a few of what we receive.
And when you see syringes, is there anything other than just the syringe itself that you might see with it?
When it's submitted, so sometimes we will receive a syringe and it could potentially have a liquid inside of it where it's loaded. Other times we have syringes that are submitted, and if there are caps still present, the safety caps that are on syringes, if those are still present, sometimes we will identify pieces of cotton that have been stuffed into the caps that are also present with the syringe.
Are you familiar with why cotton would be associated with the syringes?
Yes, we have seen cotton in the caps of syringes because typically the cotton is what is used it's like a filter, just like you have the cotton on a cigarette. It's like a filter that when the liquid is being drawn up into the syringe, they will filter it through a piece of cotton. And sometimes that piece of cotton is saved and put into the syringe cap.
I'm going to direct you to the case that we're here for today involving Matthew Broadwater and the Eastlake Police Department. Did there come a point in time when evidence was submitted to the crime lab regarding this case?
Yes.
I'm going to hand you, it's been marked for identification case exhibit 5. Just ask you to take a look at it and tell me if you know what that is.
Yes, I do.
Okay, what is it that you have before you on case exhibit 5?
So State's Exhibit 5 is a copy of the submission form that was submitted along with the evidence, and this is for Eastlake case number 22-1527, and it is laboratory case number 22-1051.
And that 22-1051, where is that on that submission form?
So up at the top, it's hard to see in a copy, but up at the top is where a barcode is placed by the laboratory. And this barcode is what is generated when the evidence is put into our computer system. So that is our unique identifier that was created for this case.
And what was submitted to you? What type of items were submitted to you?
So there was one item submitted, and it was written on the submission form as a needle with black residue and a dollar bill with brown residue.
And do you recall eventually getting those items to test?
Yes, I do.
Tell me, when you have items like that, what kind of testing and what machines are used to do that testing?
So for this case, what was done is first, I'll say I retrieved the evidence from the evidence room, the locked evidence room, and I date and initial the packaging on the evidence. If there is a weighable amount of a substance present, that is recorded using our balance at the lab, and that is just the weight of the substance, so it's removed from any packaging that it's contained within, and that the weight that is reported is the weight of just that substance. When I'm dealing with syringes, typically the instrumentation that is used is known as the gas chromatograph mass spectrometer, and that's GCMS for short. And this is looking at all the components of my sample and it's going down to that molecular level of the substances that are present. So the first portion is the gas chromatograph, and that instrument will separate out any components within the sample from one another. This is similar if you take a bucket of different size balls and you were to roll it down your driveway. So say you have a tennis ball, a golf ball, a basketball, and a bowling ball. That golf ball is going to travel really fast down your driveway because it's very small and light compared to the bowling ball, which is larger and heavier. Molecules will travel through our gas chromatograph in a similar fashion, where you have your smaller molecules travel very fast through the instrument, while the larger ones take a little bit more time to travel. So that allows for a separation to occur from all of the components in the samples that I am testing. Once that separation has occurred, it goes on to the mass spectrometer instrument, and this is where those components are broken into fragments. And we like to view these fragments as the molecular fingerprints of the substances that are present. So each drug that we typically work with has a very unique molecular fingerprint that is created when it's fragmented. And these fragmentation patterns, so if you take a china plate and you were to break it exactly the same way over and over, you expect that plate to fragment the exact same way. So no matter what case I'm analyzing and reviewing, say if I had methamphetamine present in that case, that fragmentation pattern is going to be the same from each case. So that's how I'm able to identify what substance is present just based on that fragmentation pattern. So that's the first portion of testing that is done. If I have a solid substance that is also present in a case, I will use an instrument known as the FTIR, which is the Fourier Transform Infrared Spectrometer. This is also going down to the molecular level of my substance, But instead of separating out the substances and fragmenting them, it's looking at the molecular vibration that is created by that substance when infrared light is introduced to it. This is similar to if you have a guitar and you strum the strings of a guitar, each string vibrates differently. You have loose strings and tighter strings, so you have looser vibrations compared to tighter vibrations. Molecules vibrate the same way just based on if they have loose connections to one another or tighter connections. That molecular vibration pattern that's created is able to allow me to potentially identify what substances are present within that sample. The only disadvantage with the FTIR in a case where you're dealing with multiple substances within your sample is all of those vibrational patterns are competing with one another. So I may only be able to see the vibrational pattern of a portion of the sample or all of them together, so I cannot make a true identification from that analysis.
Now, when, in this particular case, when with that evidence submission form and that evidence was submitted to you, how was it submitted to you?
That was, those items were together and they were in an envelope and then a heat sealed plastic bag.
For the record, I have State Exhibit 6A, B, and C. And these to you. Ask if you could take a look at them and ask if you recognize what those are.
I do.
Starting with 6A, what is that?
So 6A is a photograph that I took of the exterior front portion of the evidence. This was when my analysis was completed. You can see we have the barcode that was created by the laboratory. I have my initials and the date when I started my analysis, and then it's also sealed with my initials on both the envelope, and then I heat sealed the plastic bag and initialed it. 6B is a close-up of the barcode of the evidence, and so you can see more clearly, if I flip it this way, that it's for laboratory case number 22-1051, and then you can also see more clearly my initials and the date when I started my analysis.
Okay, what about 6C?
6C is a photograph of the back of the evidence. So this is just showing the back part of the envelope, and then you can also see I place a fluorescent sticker on the evidence just to notify the agency that the evidence that's contained within contains a potent opioid or more than one potent opioid, just so that they're aware, and then they can do whatever their procedures are for storing this type of evidence.
How does the potent opioid, how does that relate to fentanyl?
So fentanyl is a potent opioid. It's known that fentanyl is 50 times more potent than heroin. And then with the other fentanyl-related substances, their potencies, some of their potencies are known, but some are unknown, but we know that they're more potent than heroin.
I'm going to hand you now what's been marked for identification, State's Exhibit 4A through 4G. So we look through those and tell me what your point is.
Okay.
And do you recognize what those photographs are?
Yes, I do.
Let's start with, I believe it's A, B, and C. Ask you if you could explain what we're seeing in the photographs and how it relates to this particular case in drug testing.
Yes. So 4A is a photograph that I took of the syringe that was submitted in this case. Excuse me. Allergies are just terrible right now. So 4A is of the syringe. It was in a syringe tube. And so this is just the front showing what the syringe, excuse me. Can I have a little bit of water? Excuse me. Yeah. It's all the talking gets it going. Thank you. Okay. So 4A is showing what the syringe looked like. 4B is an image showing the barcode that I placed on the evidence. So you can see it's laboratory case number 22. 22-1051, and my initials are there. And then this 4C is a close-up of the barcode, so it's more clearly seen.
Now looking at the size of the syringe in the photo, that's not two sides, is it?
What was that? Sorry.
The syringe that's in the photo, is that a larger version of what the syringe actually looks like?
It is more of a blown-up view to see. It was more, it's just a typical, if you've ever seen an insulin syringe, that is the size of the syringe that it was.
All right, then looking at the remaining,
Yes.
360 through, I believe,
Yes. So,
you need some more water.
oh yeah. So 4D is showing the evidence of the dollar bill that it was described on the submission form as a dollar bill with brown residue. This is showing after I completed my analysis, so everything has already been separated from one another. So there was a black glove, the dollar bill, and then the brown solid substance that was present inside of the dollar bill.
And how was the dollar bill submitted to you originally?
The dollar bill was folded up and it was placed inside of the glove. And then the brown substance was inside of the dollar bill.
And there's a plastic bag, you can see the brown substance in there. Was
Yes.
that plastic bag part of what was submitted by the agency, or is that something that you did?
The plastic bag was the plastic bag that I had at the lab. So I just put the substance into the plastic bag to ensure that it was sealed up when I finished my analysis. So 4E is just the back of the plastic bag to show more of the black glove that was present. You can see a little bit of the dollar bill, and then you can see more of the brown solid substance that was in the plastic bag.
Okay, and then X?
4F is a close-up of the plastic bag that contained the brown solid substance, and you can clearly see the barcode that I placed on the evidence with my initial. And then 4G is just the back of the plastic bag to get a better view of the brown solid substance that was present inside of the dollar bill.
All those photos that you looked at on the bag, looking at those, do they all fairly and accurately depict the evidence that you analyzed in this particular case?
Yes, they do.
And with the syringe, what kind of analysis did you do and what were the results?
So the syringe was using the GCMS, and if I refer to my notes, the results were, the syringe was found to contain des-alkyl-gadazepam residue, which is a Schedule I substance, des-propionyl fentanyl, also known as 4-AMPP residue, a Schedule II substance, and fentanyl residue, which is a Schedule II substance.
And then I'm going to hand you, show you, first of all, Opposing Counsel States Exhibit 7. Let me approach. You recognize the States Exhibit
Yes, I do.
And what do you have in front of you?
So State's Exhibit 7 is a copy of the laboratory report that I issued for this case, which is laboratory case number 22-1051. It includes case information, the description of the evidence that I created for the case, my findings for the evidence, and it's also concluded with my signature.
So when we're looking at, evidence item, it says item 001, what is submitted as 001, and then are there any other subparts of that?
Yes, so when the evidence was submitted for item 1, how I described it was that sealed plastic bag containing a sealed envelope containing, and then I break down the different items that are present within that envelope into sub-items. So item 001-A was one sealed plastic container containing one syringe with needle and one piece of cotton. And item 1B was one glove containing one folded $1 bill containing pieces of a brown solid substance.
So the first results that you gave, would those be in reference to item 001A?
Yes, they would.
And then what about looking at the folded dollar bill with pieces of the brown solid substance one? What were the results of that?
So the brown solid substance, that was found to be 0.12 grams net weight, found to contain parafluoroacetylfentanyl, which is a Schedule 1 substance, parafluorofentanyl, which is a Schedule 1 substance, despropanylfentanyl, also known as 4-AMPP, which is a Schedule 2 substance, and fentanyl, which is a Schedule 2 substance.
And in doing that, do you also have a weight for that?
Yes, the weight was 0.12 grams net weight.
And so when we're seeing the photographs of what you observed, why don't we bring those into court?
Going back to the potency of the evidence, not wanting to potentially contaminate the courtroom and put potential hazards of people coming into contact with it, especially not knowing all of the potencies of the substances. It's just for safety precautions that photographs are used instead of bringing the evidence in and having it potentially come out of the packaging that it is within.
And the exhibit that you have there, is that the original or a copy?
This is a copy.
And does that fairly accurately depict the original and all the information contained in the original?
Yes, it does.
Would there have been anything else additional that you would have done in this case after you did that analysis?
Once my analysis was completed, I took the images of the evidence and sealed the evidence, and then it was just returned to our locked evidence room where it awaited being picked up by the submitting agency.
Cross-examination?
Thank you, Your Honor.
Good afternoon, Ms. Gilson, how are you?
Good, how are you doing?
Good. You described the process by which you get evidence submissions.
Yes.
Fair to say, the only evidence that you analyze comes from police departments?
That's correct.
And if I recall correctly, you said that there were 4 different types of testing that you do at the lab that you work at the Lake County Crime Lab?
There, if weighing it, the GCMS and the FTIR?
No. My notes, fingerprint, firearm, toxicology. And
Oh, yes, you're correct. Yeah, sorry.
and how many people work at the crime lab?
We are at, I want to say we are around 13 to 14 analysts.
Okay.
So I can't remember. I work with them every day, and I can't remember how many I work with.
13 or 14?
Yeah.
Of that 13 or 14, how many do similar testing to what you do?
In my area, it's myself, my supervisor, and then one other analyst.
Okay, so that leaves about 10 or 11 people that are doing these other types of tests.
Yes, that's correct.
Any idea how many people work on fingerprinting?
We have 2 analysts in the fingerprint section. One is currently away at firearms training.
And what about DNA?
DNA, we have 2 analysts and 1 technician.
Okay. When you get a submission from a police department, who decides what type of testing is going to be done on the submission?
The submitting agency determines the type of testing.
Okay. And the test on the samples that were submitted in this case, what types of testing were requested?
Just the controlled substance testing.
Okay. So what the substance is and what it weighs?
That's correct.
Any inquiries about fingerprints present on either the dollar bill or the syringe?
No, there was not.
Any requests for DNA testing either on the syringe or the dollar bill?
No, there was not.
Shifting gears just a little bit. You said that that's a large picture in State's Exhibit 4A, the syringe.
Yes.
How big are they? If you could give an approximation.
So looking at the syringe, I would say this marker is about the size of the syringe that I was working with.
Okay. I may have one moment. Nothing further. Thank you.
Any redirect?
Thank you. With items that have or potentially contain fentanyl, does the crime lab do DNA and fingerprint testing on items with fentanyl?
No, we do not.
Even if it's requested?
That's correct. We will issue on our report if there was a request for fingerprints or DNA stating that those items will not go on for further analysis.
Even if the items were found on a person?
Correct.
You have them further.
Anything based on that?
Can I understand, so you're saying you would refuse to do DNA or fingerprint testing?
It is our lab policy just to keep the other employees of the laboratory safe from exposure.
And so you would deem, so you could test the substances, but not the items that they were contained in? Is that what you're saying?
I can test the substances based on my training for testing and the safety precautions that we take for testing, but to keep the other employees who have not been trained safe, we do not allow it to travel further through the laboratory.
Okay, so it's a training issue, not the fact that those tests, that testing can't be done.
And it's also the policy. It was a policy put in place by our director.
Okay, nothing further. Thank you.
All right, you may step down. Thank you. Can I see counsel up here? All right, does the state have another witness?
No, Your Honor, at this time, the state would rest.
All right, ladies and gentlemen, the state is rested. That means they have presented all the evidence they intend to present. I'm going to give you about a 10-minute break or so. Remember not to discuss the case. Don't look for any other information from any other source, and do not discuss or conclude anything until this case is submitted to you. We'll see you in a little bit. All right, have a seat. And what are the exhibits that I know you've admitted some of them, but what others are you seeking admission of?
Okay, I know that we have admitted States Exhibit 1A through D. We would move for the admission of 2A and 2B.
Any objection to those two?
No, Your Honor.
Okay.
Exhibit 3 has already been admitted. Looking at 4A through G, we would move for the admission of those.
Any objection to those?
No, Your Honor.
Okay.
The evidence submission form, which would be Exhibit 5.
Any objection to 5?
No, Your Honor.
Okay.
Okay, and then 6A through C, the photographs of the bag submitted, we would move for that admission.
Any objection?
No, Your Honor.
Okay.
And Your Honor, I don't know if it's your policy in terms of the crime lab reports, if you allow them to be admitted. I didn't think so.
No.
Okay. So then it would be for 8A, B, and C, it would be the booking video clip along with the screenshots.
Any objection to the screenshots?
No, Your Honor.
Okay.
Okay, and 9 has already been admitted, so then we would move for the admission of 10A through 10H.
Any objection to those?
No, Your Honor.
And then 11 was an additional one. That was the example of the folded bill.
That I would object to, Your
All
Honor.
right, I'm not going to permit that one. So everything but 7 and 11. Okay.
Thank you, Your Honor.
Mr. Fatika, do you want to make a motion?
Yes, Your Honor, we'd move for dismissal pursuant to Rule 29 based on the fact that the state hasn't met its burden of proof, particularly with regard to the illegal conveyance. I think there's been insufficient evidence to sustain that count based on everything that's been presented. Mr. Broadwater didn't give any indication that he knew that there was anything on him, and we ask that that count be dismissed.
All right. Ms. Linden?
Thank you, Your Honor. The evidence presented indicates that the defendant was standing outside of the Dollar General area over by the laundromat, that he had that syringe at his feet with his wallet and his cell phone directly at his feet, that later tested positive for fentanyl and fentanyl-related substances. When he came into the jail, he was asked several times if he had any items on him. He denied, yet he did in fact then have it in a small pocket inside of his pants that had to have been placed there at some point in time and was on the defendant's person. That was also fentanyl-related compound. He did in fact convey that into the jail in Eastlake, and when he conveyed that in, it was located there. It didn't matter that he was advised 3 times. He decided to bring it in anyway. And the next day regarding the escape, it's either that he did or he attempted to escape while under detention for the possession of the drugs or the illegal conveyance, and that information has been presented to the court as well. So we would ask that the Rule 29 motion be denied.
All right, based on the testimony and the applicable standard, it'll be denied. Let's take a short break. Mr. Fatika, give you a chance to talk to Mr. Broadwater, then we'll let Bob know when you're ready. So, Mr. Fatika, do you want to go ahead and discuss what you wanted?
Yes, if you put the voluntary intoxication instruction in, we would ask that you include the language in revised code 2901.21 or Ohio jury instruction CR 421.07. You know, that it is a possible defense if the person is physically unable or physically not capable to commit the crime.
Doesn't that relate, I mean, where was the physical impossibility here?
Because from the time that they saw him, there was no indication that he knew what was in his waistband, and he was incapacitated when they first got there. They had to help him. He was wildly on his feet.
Well, he was standing up against the wall, right?
Right.
And at some point, when it went to the ground, got back up again. All right, but I'm having trouble on this instruction with isn't the physical impossibility that the crime is, in that particular case, possession, but you got possession of fentanyl in the folded dollar bill and possession in the needle, right, or in the syringe, right? Isn't that?
No, it's just the possession in the dollar bill.
Okay, and what's the physical impossibility? Because he physically entered the jail with the fentanyl, right?
Yeah, but with help.
With what help? I mean, he was nothing.
He was arrested. They brought him in, which I know is always the case.
Right.
For illegal conveyance, but he was falling asleep as soon as they left him alone.
Okay.
So I'm just saying he couldn't have done this on his own.
He couldn't have gotten into the jail. So is the physical impossibility the fact that, to the extent that Patrolman Eden helped him from the Sally Port to the jail? That
Right.
was okay. All right. I don't see where that instruction applies because of the physical impossibility, because I think that's what that goes to. So I won't give that. Okay. And then Ms. Linden.
Your Honor, it was just a matter of saying that it's not I took this from the Decio Petramilli case. A voluntary intoxication is not an excuse for an offense.
Which Decio Petramilli case? 1, 2, or 3? Was that the felonious assault?
Yes, it is the one where he was hit over the head.
Because he could not formulate the intent to cause serious physical harm. Is that what what he was arguing?
That's what he's arguing. Here, it's just a matter of saying it's not an excuse for an offense, and that it may not be taken into consideration in determining the existence of a mental state that is an element of a criminal offense.
Okay. All right. I mean, that's applicable in this case because it goes as to the mental state. So that'll be added in. The one provision relating to Mr. Broadwater's testimony will be taken out, and that should be the final version. So Nicole will make those adjustments and give that to you, so get that before you get out of here, okay? And then you guys, in the event that you discover something between now and when we get back here, send an email to Nicole on that, okay, with regard to the instructions. If not, then we'll be here at 8:15, okay? All right, see you tomorrow.
Thank you.
Just be advised that Nicole goes to bed at about 9.
Yeah.
Okay, you're good to go.
Did they change you out here or at the jail?
Jail.
I was just curious.
Judge, may I go over and grab my other file then for the 4 o'clock?
Yeah.
Thank you. You're good to go.
Okay.
Let me know about tomorrow.
I'll give you a shout as soon as I know. that's fine.
Pages. Sorry. Sometimes it's more. You wanna know something about Judge Carnacci? First time she came in, and she didn't realize she should have sit through the jury instruction. She said, just sit through the jury instruction. I'm like, yep, you do. You can't go anywhere. Feel free to leave.
All right, thank you very much.
Thank you, sir.
No, I'm
Are you
good.
let me know?
All right.
Okay.
We will see you. Have a good one.